which means we are getting ready to get started with the broadcast. If you're not familiar, we normally wait a couple seconds. We multi-stream here, so we want to make sure that the stream is alive across the internet. We're on Facebook now. We're on Periscope now, even though it's going away soon. But our home base, as always, is YouTube, and we want to make sure that things are working there as they should be, and it looks like they are. So let's get started. And hello, my friends. Welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful, sunny Scottsdale, Arizona, where my team and I, over the course of many years, have helped to represent thousands of good people facing criminal charges navigate through the criminal justice system. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a thing called justice. And it all starts at the top with the politicians, the ones who write the rules and pass the laws that they expect you and I to follow. But sometimes they have some difficulty doing so themselves. And so that's why we started this program called Watching the Watchers, so that we can together shine the big, beautiful spotlight of accountability and transparency back down upon that very system, with the hope of encouraging some meaningful change. That's why we're so grateful that you are with us here today and a part of this broadcast. Got a lot to get into. There were some happenings over the weekend. We know that Donald Trump was on the phone tweeting away this weekend. He gave us some new things that, of course, we have to talk about. Big news, he says, is coming out of Pennsylvania. We have a new Supreme Court lawsuit that was filed by Donald Trump himself as a candidate, as the presidential candidate, as an individual, which is a little bit different than what we've talked about previously, where you have Texas filing the lawsuit, a state versus another state. This is now Donald Trump, who is sort of renewing some underlying claims. He's at the Supreme Court's door. Two documents were filed there. One is a petition for a writ of certiorari, and the other one is a motion for expedited consideration. They want the court to really drop everything and address it. So we need to talk about that. We're going to spend some time breaking down those two documents. Some other sort of rumors kind of flying around. There was an indication that Sidney Powell was at the White House. We want to talk about the Trump legal team and what their strategy is, because it's looking like, they're going to fight this thing all the way up until January 6th and even maybe beyond that. So we want to take a look at what that means and how legally that might fit. And then at the end of the program, we want to talk about this new congressional bill that's sitting, I think, somewhere in Washington. Looks like they're going to pass this bill later tonight, a big congressional spending bill, something like $2.4 trillion. $900 billion of that is in new money right now that people are going to get. It's going to be dispersed around the world, and Americans are going to go home with just a little bit of a little Christmas bonus. We want to talk about what that means. So let's get into it. Before we do, I want to remind you, if you're not a regular of the program, now's a good time to go ahead and hit that subscribe button. We would love a like, a thumbs up, a share of the show. YouTube, because we talk about this election stuff, kind of put us in this little bit of a bubble. We've noticed our channel has basically been stagnant for the last week, and since YouTube put the limitations on us, and that's okay. We love talking about this stuff, but a thumbs up or a share would be very much appreciated. It would just help spread the word a little bit. Join us over on Discord. That's our live chat. It happens before the show and after the show, of course, on YouTube. Now you can talk in the chat as it's going literally right now, but after the program, that's where we hang out. And a copy of my slides are all going to go in the Discord server. So you can access them, see the sources, take a look at them, and there's a copy of my book in there as well. So enough of that. Let's get started. The big rumor of the weekend, I think this was sort of percolating on Friday night over into the weekend. We see that Sidney Powell, there were some rumors that she was over at the White House. And so this came from the Gateway pundit, and another news person by the name of Jeremy Diamond said that spotted tonight at the White House attorney and conspiracy theorist Sidney Powell. So apparently, if you bring election claims, as we see, you are a conspiracy theorist. I'm sure I've been lumped into that bucket many, many times. That's okay. So it says Jeremy Diamond and Abdallah from CNN and I saw her leaving the residence of the White House shortly before 9 p.m. She denied meeting with Trump tonight. When pressed again, she said it would be none of your business. And so once again, that was posted by Cassandra Fairbanks, who's a good follow over on Twitter. She's pretty hilarious. Says, breaking, Sidney Powell spotted leaving the White House on Sunday evening. So that claim has been corroborated by two individuals. This one individual by the name of Jeremy Diamond, somebody else named Abdallah over at CNN. They're saying that she was there. There was some other indication that General Flynn was a part of the entourage and some other individuals. And, you know, it's sort of hard to comment on this because it's hard to differentiate the legitimate commentary or the legitimate reporting versus the illegitimate reporting, but there was some conversation, some talk that they were trying to figure out what to do about this election, that Sidney Powell was there to potentially be appointed as a special counsel who's going to be, sort of running the election investigation in a post-Trump presidency. So if Trump, ultimately loses this thing, he was thinking about, the rumor is about appointing Sidney Powell to be a special counsel so she could stay on after the administration ends and then continue the election fight. There was some talk about that. Again, not confirmed. We also know that there was, or we don't know actually, but there was some rumor, there was some conversation about this idea of martial law. We've heard a lot about this. General Flynn was there. He has sort of been on Twitter and around the different news agencies talking a lot about that, saying, not martial law verbatim, but he is talking about using the military to get in and sort of interfere or commandeer, maybe seize Dominion voting machines and potentially even rerun elections in the compromised states, according to General Flynn. I, of course, on this channel have been a big opponent of any sort of military intervention or martial law. That just is unsettling to me. Not that I disagree with continuing to pursue the electoral claims. I think it's still worth talking about and investigating because we really don't have any answers. We've been following this story for 6-7 weeks now, and most of the courts that we've analyzed have really not heard a case on the merits. There's been a little bit of sort of biting around the edges of the problem, but not much. We haven't really seen a full case go to fruition through a trial or evidentiary hearings or anything like that. Most of these have been dismissed on latches or mootness or standing, and it's been a little bit of deflating. So they're talking about at the White House some alternative approaches and some other things that they can do. Now, it is, of course, Donald Trump style to tell you more about what's coming and sort of tease this stuff out a little bit on Twitter. This was today, it looks like, very early this morning at 5:24, presumably after the meeting with everybody over at the White House. He says, hey, big news is coming out of Pennsylvania. Big, very big illegal ballot drop that cannot be accounted for. Rigged election, he says. And of course, we have the Twitter disclaimer saying that this claim about election fraud is disputed, which you're probably going to get on the bottom of this video as well. As we know, many of the people on YouTube and many of the tech people are saying that this is already done and over, even though Congress has not certified the results or accepted the results that have been pre-certified by the states in terms of casting the electoral votes. So you're going to see that. And of course, we need to mention that YouTube and most of the tech companies have already considered Joe Biden to be the president-elect. And that is their statement, and they're sticking to it. So this is Donald Trump saying, no, there was a big problem out of Pennsylvania, a lot of ballots that can't be accounted for. Then we learned today, actually yesterday is when they filed this, but it's a lawsuit out of Pennsylvania, 3 Pennsylvania cases, in fact, that are now knocking on the door of the Supreme Court. So Donald Trump and his team, they filed this document. This comes from Just the News, and it says Trump wants the Supreme Court to overturn the Pennsylvania election results. We can see here from the article from the Washington over at the AP. It says, undeterred by dismissals and admonitions from judges, President Trump continued with its unprecedented efforts to overturn the results of the election, saying it filed a new petition with the Supreme Court. It is trying to reverse a trio, and so I want to point this out because we're going to spend some time talking about these types of cases, a trio of Pennsylvania Supreme Court cases having to do with mail-in ballots, and ask the court to reject the voter's will and so on. Now, a lot of this stuff, of course, is going to be, up for debate. We've talked about this. Is it really overturning the will of the voters if those ballots were fraudulent? You can't make that claim. So you have to pick one sort of premise that you want to base your arguments on. And so the standard premise here is that every single vote is legitimate. The burden is on the petitioners. So here, the Trump team to go in and sort of flip that burden around. Right now, the presumption here, just like you would have a presumption of innocence in a criminal case, supposedly. I could debate that topic for a while, but what you're saying is you have a presumption of legitimacy, a presumption of credibility that the government ran the election legitimately, and now it's Trump and his team, it's their burden to overdo that, it's to overturn that, to reverse that. So when you read these articles, you have to take that with a grain of salt. That is what they are operating under. They're saying this was all legitimate, everything was fine, and now Donald Trump is trying to orchestrate this unprecedented reversal of an election. But if you look at the premise from the other side, if you sort of flip that over and you say, well, what if this 300,000 votes or this 700,000 or however many votes they're challenging, what if those are actually sort of removed from the equation because they're not credible? then the premise flips. Now it's the premise that Donald Trump won the election, and so that's what they're going to continue to be operating on. So this article, we go back, it says he's asking the court to swiftly move so that it can rule before Congress meets on January 6th, and we're going to talk about that. And before we get into the lawsuit itself, let's take a look at what Trump and his team had to say, because what we're trying to sort of decipher in this next little bit of analysis is what is the basis of this new claim. If you've been following the channel for some time, awesome. You've been joining us along as we've been analyzing lawsuits after lawsuits. I mean, for 6 weeks, we've just been boom, boom, boom. We've talked about every single one, every single battleground state. I don't think we've missed any of them. We've had Georgia, Pennsylvania, Michigan, a lot of Pennsylvania, several out of Wisconsin. We even covered Arizona. We covered Nevada. There's a lot. And so many people are wondering, well, what the heck is left? What else can they contest? What is their strategy moving forward? On December 8th, we had the safe harbor deadline, which is when YouTube implemented its new policy. They said that was it. That was the deadline. Then we had last week on December 14th, we had all of the states actually cast their electoral votes. And a whole nother sort of slew of individuals out there in the commentariat and the people who run blogs and things, they're all saying, no, this is the deadline. So this is when we can stop talking about it. And there's other people, like myself included, who say, well, there's a pretty good argument to say January 6th is the ultimate deadline because that's when they count the votes. That's when Congress opens up the electoral votes that were cast by the states, reads them, hands them to the president of the Senate, which in this case is going to be Vice President Pence, and he can read and nominate and sort of when he enunciates who the next president is, that's when the rules say that's it. That's the end of the day. That's the end of the ball game here. And so, we're still kind of, moving forward. But at this point now, we've seen something like 50 lawsuits that have been filed by the Trump team. We've seen the Texas lawsuit that had the backing of several hundred, if not more than that, Congress people, attorneys generals, a number of people who were signing on to that lawsuit to sort of give it some weight, give it some legitimacy, say, hey, Supreme Court, this isn't just an angry Donald Trump and Rudy Giuliani. There are a number of different states involved. We had Texas, literally the state of Texas, filing the suit, joined by a dozen or so other states. I think even more than that, 17, 18 states in total. So a lot of effort, a lot of energy, and the Supreme Court still said, no, not any good. You don't have any standing here. Sorry, your case cannot be heard, even though it's like original jurisdiction. It's in the Constitution. We talked about it. We showed you the rules, showed you the law. They still didn't want to have it. So at this point in time, people are just sort of scratching their heads going, what else is there to say? What else can we address here? Why is Donald Trump continuing to fight this thing? Why is there another lawsuit that is going in front of the Supreme Court? Let's see if we can tease some of that out and decipher what is actually going on here. So yesterday, right after the filing in the Supreme Court, we have the Trump campaign, which is taking the constitutional fight to the Supreme Court. So they posted this over on donaldjtrump.com, and you can see this is a statement that comes from Rudy Giuliani, the president's chief attorney. We've been seeing him running around a lot at the different legislative hearings and so on. And he says, this is his statement. He says, Donald J. Trump for president and the campaign committee, they filed a petition in front of the Supreme Court to reverse a trio of the Pennsylvania Supreme Court cases. So let's back this up a little bit. So right now, remember, we've talked about one of these. There was one called Pennsylvania versus boockvar that went all the way up to the Supreme Court before the election. Okay, we've talked about it here. We talked about, I think, 6 or 7 lawsuits that were filed before the election. Many of these lawsuits were filed by Democrats. In this case, it was the DNC, sued Kathy Boockvar, who is also a Democrat, because they wanted to modify some of the rules. That case was dealt with. The Pennsylvania Supreme Court came in, changed some of the other rules, issued a ruling in that case, and then the Republicans and everybody appealed that up to the Supreme Court. So we're going to be spending a lot of time talking about the Boockvar case. And the Boockvar case was the one that went up to the Pennsylvania Supreme Court because Amy Coney Barrett was not on the bench yet. It was a 4-4 decision, so we had only 8 justices, and they split down the middle. John Roberts joined the liberal wing. He's the Chief Justice. And together, they decided that there's no decision on this case. So when you have a 4-4 split, there's no decision. The lower court decision stands. So what happened here is that the Pennsylvania case was deemed to be the end of the line on that, as it were. And what happened there is that Judge Alito issued a pretty big a dissenting opinion saying this is going to come back, this is going to be a problem, and they're really latching onto that. So that's just to frame this out a little bit more to catch you up to speed if you haven't been following along. So we're talking about these lower level court cases out of Pennsylvania that have been sort of, bubbling around the state of Pennsylvania, bumping their way up to the Supreme Court, getting knocked back down by the Pennsylvania Supreme Court. The Trump team here in this new petition is saying we want to renew all of those underlying claims. We want to revisit those cases because they are wrongfully decided. So let's go back. That was I should have sort of framed that out a little bit earlier, but let's go back to the Trump team and their statement. So they say they're trying to reverse those 3 Supreme Court cases that all illegally changed Pennsylvania's mail balloting law immediately before and after the 2020 election. They're saying it violates Article 2 of the U.S. Constitution and Bush versus Gore. This represents the campaign's first independent U.S. Supreme Court filing. So, Donald Trump for a long time has been saying that, oh, those aren't my lawsuits, all the ones that have been, being lost in the various courts. He's saying those weren't mine. He's saying this is our first one. Rudy says this is our first independent Supreme Court filing, and we're seeking relief based on the same constitutional arguments that were already raised in Bush versus Gore during the 2000s. And they're quoting here, this petition follows a related Pennsylvania case where Justice Alito and 2 other justices observed the constitutionality of Pennsylvania's Supreme Court decision, which was extending the statutory deadline for the receipt of the mail-in ballots from 8 p.m. on Election Day to 5 p.m. 3 days later. They're saying that change has national importance, and there is a strong likelihood that the state Supreme Court decision violates the federal Constitution. And this was the same thing we were talking about. Remember what happened here? There was a lot of litigation. There was a lot of new laws that were being passed around many states, even in Arizona, probably your home state too. Everybody was trying to change the rules at the last minute, largely to comply with COVID. Everybody's freaked out about COVID. What are we going to do? Grandma's not going to be able to go vote because of COVID. So we have to change all of these rules. And one of the rule changes out of Pennsylvania was they're going to move the election back by 3 days. So it was scheduled on November 3rd. They pushed it back 3 days to November 6th, I think it was. Are those dates right? And it was moved back though on their own accord. Basically, the Supreme Court just came in and said, we're going to move those dates around. Why? Whatever basis, they found some sort of obscure provision in the law that in times of emergency, we have this massive ability to just change things in order to fashion what are called equitable remedies. So, even though they technically kind of don't really have that power, they can, because of COVID, because of the emergency, because of the lockdown orders, because of all this, executive authority, they're just going to go ahead and change some things around. And when you start, analyzing that, whether you're happy with the outcome of Pennsylvania, whether you're happy that Joe Biden, technically, quote, won Pennsylvania right now, you have to ask yourself, are you okay with courts just stepping in and changing the rules? This has already been decided by the U.S. Constitution, which says the legislature is the body, the appropriate governing body that is allowed to modify the election rules. The courts can't do it, but they did here in this case, and they reached into sort of their toolbox and they picked out stuff that supported their claims. So now what they're saying is that was illegal. And we can sort of gather from this that a big part of their request in these upcoming lawsuits, or this current lawsuit in front of the Supreme Court, is to address some of this mail-in voting and some of these other, I would say, illegal separation of powers arguments, saying the Supreme Court stepped over the line and tried to take over some of the control, some of the rulemaking ability that are delegated to the legislature. So let's finish up with Rudy's statement, and then we're going to get into the motions. All right, so here is the second part of his statement. He says, the campaign seeks to reverse 3 decisions which eviscerated the Pennsylvania legislature's protection against mail ballot fraud, including A, prohibiting election officials to check signatures, B, eliminating the rights of campaign to challenge the mail-in ballots during canvassing, and C, holding that the rights of the campaigns to observe the mail-in ballots only meant that they were allowed to be in the room. And then finally, D, eliminating the statutory requirements that voters properly sign, address, and date mail-in ballots. So you can see this is all, I would say, accurate. It's all, somewhere in the petition that is filed with the Supreme Court. So if we break it down, prohibiting election officials from checking signatures, eliminating the ability to challenge the mail-in ballots for forged signatures, It's another observational challenge, which we spent a lot of time talking about, and then eliminating sort of the statutory requirements for properly signing, addressing, dating. And so it's all mail-in ballot stuff, a lot of what we've talked about. And they're finally saying that the petition here seeks all the appropriate remedies, including the vacating the appointment of electors that have already been committed to Joe Biden, and then allowing the Pennsylvania General Assembly to select their replacements. The campaign moved for expedited consideration, asking the Supreme Court to order responses by December 23rd. That's in 2 days from now, and a reply on Christmas Eve, December 24th. They're asking the U.S. Supreme Court to rule before January 6th, which is when the Electoral College meets and then officially counts the votes. So we are going to go through two different documents. Number one, I want to go through the first request, which was, it's really, you can take these in either order that you want, but we're going to go through the petition for a writ of certiorari. So that is asking the Supreme Court to hear the case. Remember, the Supreme Court doesn't have to hear any case. There are some pretty strict rules and requirements and some formalities on how to get a case before the Supreme Court. So if you ever in your life have said, I'm going to take this to the Supreme Court, the likelihood of that ever happening is pretty low. And the reason I can kind of poke on that one is because I've said that probably 100,000 times, right? And we're going to take this one to the Supreme Court, damn it. And, the likelihood of that ever happening is very low because they only will take, a very small sliver. I think it's like a 0.1% of the cases that exist ever even make it to the Supreme Court because they have to grant admittance into the court. They have to grant a petition for a writ of certiorari, and then only at that time will they schedule oral arguments and entertain the case further. We saw what happened when they denied it. We had what I thought was a well put together lawsuit from Texas that had a lot of legitimacy behind it, major government officials from around the country, a lot of interest, and the Supreme Court just said, nope, we can't hear it because of standing. And that lawsuit was declined, right? That's one example of the Supreme Court not hearing a case. So we're still at that stage. Just because he filed the lawsuit doesn't mean that they have to do anything with it. They could just deny it outright and just say whatever reason they want. Nope. Denied. We can get another, one paragraph order from the Supreme Court that doesn't give us anything useful, and they can just go about their business. I'm hoping that doesn't happen. I was hoping that wouldn't happen in the Texas lawsuit, but we'll see. In my mind, largely at this point in time, it's hard to rely on the Supreme Court to give us any clarity on any of this stuff, and we'll see if that changes. So the second document that we're going to talk about, and the first one we're going to get to right here, is what's called a motion for expedited consideration. So as we all know, the Trump team, his legal team, is on a hard clock. They're already missed some deadlines. Now, they say that those deadlines are inconsequential, but the courts haven't. And, a lot of the American people are probably sort of, accepting more and more of this. So they need a response sooner rather than later because there is a lot of political legitimacy that they need. They need some political cover in order to move this stuff forward. Remember, we've talked about sort of the contingent election process. We've talked about dueling electors. We've talked about if they were to challenge the votes on the House floor, then that could basically require that both parties, both houses in Congress break, and then they have debates about whether to count one particular state's electoral votes or not. And so, they need some cover. If you're going to find a senator who's going to be willing to throw his reputation on the line in order to object to some of these electoral votes being counted, it would be helpful for them if the courts came back out and said, you know what, there are some problems here. You know what, maybe those mail-in ballots were unconstitutional. Maybe the judiciary in Pennsylvania shouldn't have stepped all over the toes of the legislature. If the court were to weigh in on that, it may give some senators some cover to join the House of Representatives. And then, you may even get some Democrats who flip. If the courts lean in here and say there was some pretty serious fraud or these are major problems, you may start to see some momentum. And that's what Donald Trump and his team, I think, could really benefit from. So this next motion is to say, hey, court, pick up the pace on this stuff. Okay, here's why we really need you to rule quickly. Sidney Powell has some lawsuits, I think, in front of the Supreme Court, and many have heard response deadlines are late, I think in the next year. And she's going to be filing, I heard, similar motions, also asking the court to expedite the process a little bit. So before we dive into the substance that's in the petition, let's take a look at this motion for expedited consideration. This, again, was filed, I think it was yesterday, very, very, very recently. And so this is not a huge document. I think this one's 7 pages long. And it says here, this is the need for expedited consideration. The court should review the Pennsylvania Supreme Court decisions and enter an appropriate remedy on an expedited basis. And they're giving us 3 reasons. Number 1, the ordinary briefing schedules that are prescribed in the rules would not allow the case to be considered and decided before the results of the general election must be finalized before following the upcoming deadlines. Congress is scheduled to count the votes and declare a winner on January 6th, which is about, what are they saying? Inauguration date for the president and the vice president is January 20th, so it's 30 days from now. These deadlines would expire before completion of the briefing argument and a decision on the merits under the court's default rule. So they're saying, okay, if you look at the Supreme Court rules, we know we got to do certain things. We can't do them right now. We know there's all these deadlines, all these rules. We read the rules. We can't abide by them. So we need you to act more quickly. Here's why. Got a January 6th deadline coming up. We got a January 20th deadline coming up. We need some action here, right? And that's obvious. We all know that. I don't think anything even to argue about that. Second, time is plainly of the essence because once candidates have taken office, it will be impossible to repair election results tainted by illegally and belatedly cast or absentee mail-in ballots. In other words, if this were to go forward without an ability to address the problem is going to carry over into the next administration. Without expedited review, the appellate rights and the court's power to resolve, and all of these things are going to be irrevocably lost. So it's kind of a now or never argument. You have to get in here and rule on this. Otherwise, it's gone because Joe Biden's going to be in the White House. Once that happens, I think they're sort of acknowledging, we're going to see here in a minute how they have a sort of an alternative argument here, but they're going to be saying that it's game over, so we need you to rule. And third, this court's expedited review will in no way prejudice the respondents, many of them which are state government agencies. They have a similar interest in the Constitution being followed. So that last point is saying, look, the respondents are capable of responding. One of the things you want to ask anytime you file a motion is, what does the opposing side have to say, right? So let's say, for example, I'm a criminal defense lawyer. I want a continuance of a court date, right? I've got a conflict. I've got, something in a different court on the other side of the state. Okay, well, I can't be in 2 places at once. I file a motion to continue that. I say, hey, can we reschedule this to another date? Very, very simple. Happens probably 10,000 times every day across the country. Everybody's moving things around on their schedule, but you still got to get the opposite side's opinion on that. So when I file a motion for a continuance to reschedule a court proceeding, the judge wants to know, okay, well, what does the prosecutor say? What does the state say? What does the government say about this? And if that would prejudice them, if that would harm them, let's say that they had something scheduled that day and they wanted to bring in an officer to come into court and offer something, for whatever made up reason, and they object to the continuance. Well, now the court's going to say, okay, well, Mr. Gruler, you can reply and we can hash it out. We can have oral arguments about that. That's just for a simple continuance. So here in the Supreme Court, they're saying, all right, well, this isn't going to hurt them. I'm sure they're going to object to this petition, and they will. There's going to be a motion from probably Mark Elias or somebody who's opposing this, and going to have probably a number of interveners, just like we saw at the last Texas lawsuit and so on. So the point here is that they're sort of being preemptive and they're saying, all right, the respondents, their government agencies, they also have an interest in settling this case because they do. I've talked about this a lot here. If this is allowed to stand, what is going to stop any government body in any state across the country from just doing whatever the hell they want with elections? We saw that thus far, there are no repercussions with changing the rules at the last minute. None, basically none. Supreme Court can step all over the legislature. Legislatures in different jurisdictions can sort of just disagree with prior legislatures. They can just, modify underlying constitutional provisions however the hell they want. They can just go in and delegate certain things to electoral commissions who can write guidelines that are in direct opposition to what the state constitution says. No problem at all. Just run elections however you want because the Supreme Court just doesn't care. And they're saying here that they should care. The states should care. The Supreme Court should care. There are a lot of interest that the state governments have in settling these claims. It's not just about Donald Trump. It's a bigger issue. If we go to 2024 and we have the same set of problems, the country's going to be thrown in the middle of this once again. And both sides are going to try to outmaneuver one another. Both are going to try to, change the rules at the last minute, or it doesn't have to be last minute now. They can just go in and change them to serve them best. And one of the biggest concerns that I've had was it's just going to come down to who can cheat better, who can craft the rules that suit their demographics the best, and they're going to exploit them to the end of the earth. So in my mind, it is something that needs to be addressed one way or the other. We're going to see if the Supreme Court does it. And then lastly, and this was the final part of the not the final part of the motion, but the final thing I wanted to talk about related to this motion for expedited consideration is this one got a little bit of, I would say, concerned or feigned concern. Let's say, a lot of people who are in the legal space tend to be very anti-Donald Trump. And so when they see language like this, they just jump through the roof. Let's take a look at it, and then we'll show you a response. So this was the final reason why the court should hear this case in an expedited manner. The court should hear this quickly because of this. Finally, if this matter is not timingly resolved, not only will petitioner, but the nation as a whole may suffer injury from the resulting confusion. Indeed, the intense national and worldwide attention on the 2020 presidential election only foreshadows the disruption that may well follow if the uncertainty and unfairness shrouding this election are allowed to persist. The importance of a prompt resolution of the federal constitutional questions presented in this case cannot be overstated. So one more time, the language that is kind of raising some eyeballs around the legal communities are this language. The national worldwide attention only foreshadows the disruption that may well follow if this is not answered. Many people are saying, what does he mean by that? What is that disruption? Is he going to implement martial law? Is he going to seize power of this country? Is he going to take control of the nation? That's what kind of Josh Douglas is talking about. Kind of. He posted this on Twitter. He's not making that exact argument, but he's a little bit concerned about this language. And Josh Douglas is he is a UK College of Law professor. The UK is the Kentucky Rosenberg College of Law. This is him over on Twitter with his mask on saying election law, voting rights professor at the UK College of Law. He's got a new book, Vote for Us book, and so on. And he posted this today. He says, and the cert petition compares this election to, you guessed it, the election of 1860, which we are going to talk about here a little bit. And they are literally, he says, they are literally asking the Supreme Court to intervene by raising the specter of civil war. Ooh, he said, and he has a little bit of a screenshot here. It says, this is a quote from the text of the lawsuit. He says, our country is deeply divided in ways that it arguably has not seen since the election of 1860. There is a high level of distrust between the opposing sides. And so apparently that sentence is raising the specter of civil war. And I like it when people say, hey, say literally, and then what they're talking about literally doesn't have that in there. So he's saying they literally asked the Supreme Court to intervene by raising the specter of civil war. I mean, I guess technically you could make that argument that he's saying our country is deeply divided in ways that it arguably has not been since the election of 1860. I don't know that I would say that that's literal. I mean, literally, to me, would say that they were talking about if you don't answer this question, there will be a civil war. There's going to be a war. Trump's people will, ask to secede or any one of those things, or they may secede or any of that stuff. He's not talking about the Civil War in the lawsuit at all. He's just talking about the election of 1860, which is before the Civil War, which started in, I think, 1861 to 1865. I think that's right. And the election of 1860 was the election of Lincoln. So I think that this is just sort of hearkening back to the history of the United States, and he's upset that they're talking about 1860, saying it raises the specter of civil war. Disagree with that. But then he goes on, and this is his opposing viewpoint. So it's worth noting that this is what he says. He says, this is a truly shocking thing to say in a legal filing to the Supreme Court. The, quote, confusion about the election is due solely to the president and his allies' refusal to accept defeat, and that disruption, and the, quote, disruption that may well follow, quote, sure seems like a veiled threat. And then he just is referring back to the same passage that I just read you. So take that's one person's interpretation, I suppose. Disagree with it totally. I don't think that he's implying that the country's going to rip itself apart. I don't think that he's saying that this is a veiled threat in any way. I read the I didn't read the entire lawsuit. It's about 276 pages, but I did read a substantial portion of it, and I didn't see that anywhere in there. But you are going to hear that. Apparently you are not allowed to contest anything anymore. You just have to be a loser and just accept it. That's it. That's according to people who have that opinion. All right, so let's take a look at the petition for a writ of certiorari. This is the meat. This is the meatball on the plate. some stuff to get into. As you can see, we've already talked about this woman here a lot, Kathy Boockvar, the Secretary of the Commonwealth of Pennsylvania. So it's Donald Trump for president versus Kathy Boockvar. And this is important to note, right? Donald Trump for President, Inc. is the petitioner. So this is his campaign. He's filing it sort of as somebody who should clearly have standing here. And we're going to see what the Supreme Court does. The attorneys down here, Bruce Marks over from Philadelphia, Pennsylvania, is joining. And then we have John Eastman over out of California, who is also joining the lawsuit. So they're counsel for the petitioners. And we're going to get into it. Let's take a look at some of the questions that are presented. So there's going to be a lot of text here. Let me sort of give you a summary of how I broke this lawsuit down. So as you probably know, if you are a regular on the channel, we've been talking a lot about these lawsuits. Sidney Powell's lawsuits, a number of individual lawsuits. We've basically reviewed, I think, every type of electoral claim, electoral fraud claim, voting fraud claim that exists. We've talked a lot about some of the, I would say, interesting concepts, ideas like Dominion was created to steal votes in Venezuela, and that has somehow morphed into something that's relevant for our 2020. We've talked about all of the lawsuits alleging procedural problems, not checking signatures. We've talked about the constitutional problems, things like separation of powers, and a lot. We've really spent a lot of time talking about basically everything. Not going to rehash all of it, right? There's a lot in this lawsuit that is rehashed. I'm not going to do that. We are going to talk about some of the issues that I think are most pertinent. Number one, what is the basis of the lawsuit generally? Because remember, they're referring to 3 other lawsuits that exist out of Pennsylvania. So we're not going to go through all of those 3 lawsuits. We're going to summarize what are the main claims here. And then I really want to address how they are going to deal with the standing, the mootness issue, some of these timing deadlines, because as we've seen thus far, those are the basis, those are the reasons why these courts are throwing these cases out. So I want to see how the Trump campaign and his lawyers are addressing those lawsuits. So these are the questions that are going to be presented to the Supreme Court. In other words, this is what they're asking the Supreme Court to weigh in on. Supreme Court typically doesn't just, resolve cases on one-off cases, right? Like, for example, if a client of ours had a DUI and we, appealed that and somehow we got into the Supreme Court, yes, the decision on that case is going to impact our client, certainly, because it's his or her case, but it's typically it's a bigger issue than that, right? What they want to do is settle a constitutional problem. They want to settle an issue that impacts the whole country. And so what you'll generally see is issues that will sort of, the Ninth Circuit, which deals with the West Coast, will be different than a different circuit, let's say the Third Circuit, and there'll be a difference of opinion. They'll say, how do we deal with, Miranda violations? The Ninth Circuit does it one way, the Third Circuit does it a different way. There's a conflict there. Now the Supreme Court needs to hear that case. And so that's kind of how they work. And here what the Trump campaign is doing is they're saying, okay, these are the issues. These are the major issues that we need you to address because they're going to impact the whole country. And so let's take a look at what they are. They say Article 2 of the Constitution says that each state shall appoint electors for president and for vice president in such a manner as the legislature thereof may direct. We have talked about that quote, 20 times on this program, a lot, because it's the basis for it, right? It comes right out of the Constitution, Article 2, Section 1, Clause 2. That power is plenary, which means it covers everything. It's enacted by the legislature in furtherance of the constitutionally assigned duty, and it may not be ignored by state election officials or changed by the state courts. And this comes from Bush versus Gore, which was decided in 2000. However, during the 2020 election, this is what the Pennsylvania Supreme Court did in 4 cases. They literally took the power away from the legislature. They're saying here, 3 at issue in this petition and 1 already before the court, statutory requirements were eliminated regarding signature verification, the right of campaigns to challenge invalid mail-in ballots. Other things were eliminated, mandates that mail voters fill in, date, and sign mail ballot declarations, and even the right of the campaigns to observe the mail ballot canvassing process in a meaningful way. Collectively, these 3 decisions resulted in counting approximately 2.6 million mail ballots in violation of the law as enacted by Pennsylvania, according to public reports. Without these protections, the resulting disqualification rate of invalid ballots was anemic, meaning over 110,000 invalid ballots were illegally counted, more than enough to have affected the outcome of the election, where the margin between the two was only 80,558. Then they're going to get into the questions. So again, let's think about this. Remember what we've talked about. The two sort of things that we need to discuss in any one of these lawsuits is the harm and then the remedy. So what is the harm? They're saying it had a lot to do with mail-in ballots. It had a lot to do with the Supreme Court out of Pennsylvania moving the rules around, and they've identified something like 110,000 ballots that were illegally counted. They're saying the margin of error here was only 80,000. So if we so now we have to sort of speculate, well, what's the remedy here? How do we fix this? So obviously we got to find some buckets of votes that don't belong there in order to close that margin, to shrink that gap of 80,000. And we have to always ask ourselves, is a court going to be willing to do that? Are they going to throw out 110,000 votes? One side's going to claim they're invalid. The other side's going to claim they're valid. How's the court going to make that decision? Not an easy decision when courts don't want to do that. They don't want to disenfranchise people. They want more people to vote, not less. So let's take a look at the key specific questions that we find here. Number one, whether the Pennsylvania Supreme Court's alteration or the suspension of state election law through its 3 decisions before and after, whether that usurped the Pennsylvania legislature's authority to run their elections, in other words. So the first question, Pennsylvania Supreme Court, they changed the election law. They either altered it or they suspended it in 3 different cases before and after the November elections. They did that. The legislature did not. Is that allowed? That's all that we're asking. I would think that would be a very reasonable question. I would love to know the answer to that personally. Can this happen again? Can courts just change the rules on their own again? There's going to be more emergencies. I just heard there's a new strain of COVID over in England. Okay, we're probably going to have another COVID or another reason to lock stuff down or another reason why somebody can't vote or whatever it is. So what is the rule here? Can the various courts step on the toes, in my mind, of the legislatures? Is that allowed or not? Supreme Court, will you please answer us on that? Because we have another election coming up, a federal one in 2 years and another big one in 4. Maybe they'll give us some guidance on that. Question number 2, whether the Pennsylvania Supreme Court, whether their 3 decisions usurped the Pennsylvania legislature's authority to direct the manner for appointing presidential electors by changing the law, including, they're saying, eviscerating protections against the mail-in ballot fraud, whether those things violated the due process clause of the Constitution, and whether Pennsylvania applying the new rules promulgated by the court during an election in only select counties where mail-in ballots were heavily favored over one candidate or another, whether that violated equal protection clause of the Constitution. So 2 pretty big, meaty constitutional issues wrapped up into that one question. 2 things we need to talk about. So due process. Due process is this idea that before stuff can happen, you got to go through a formal process. Okay, right? You may remember this from the movies. Before you are questioned, whether let's say you're suspected of a crime, the police arrest you, they take you into custody. The process there that you'll go through is they'll read you your Miranda rights, or they should, right? That's the process that they follow before they start questioning you. Miranda is invoked when you have custody, when you're in custody and they are interrogating you. So a little bit of a side note, many people will say, well, they didn't read me my rights when I was in the back of the police car. Well, you were technically in custody, but they weren't interrogating you yet, probably. Right? Once they take you to the station, now you're in custody and they're interrogating you. Boom, Miranda triggers and they have to Mirandize you. So that is a process. Now that's kind of not what due process is. Due process would be like, that is a form of due process, but due process would be, you before you can be sentenced to go to prison, you have to go and have a trial or you have to plead guilty. That's process. They can't take away one of your liberties without giving you the formal process. And so what they're saying here is that basically the Pennsylvania legislature, the court usurped the Pennsylvania legislature and they ruined the due process. So there was a process in place that said, we want to protect against mail fraud, and we're going to do all of these things. We've talked about a lot of the Pennsylvania rules on this channel. I'm not going to rehash them, but there's a lot, right? The signature verifications, no drop boxes, all sorts of reasons why mail-in balloting is problematic. As many people prior to this election agreed, many of them on the left, they've all come to the same conclusion that mail-in balloting has a lot of problems with it. And so they're saying the Pennsylvania legislature here put these rules in place, and it was to ensure due process. It was to ensure that this was done appropriately. They violated those rules. That's a violation of the Constitution. Due process is a problem. This is a problem. They violated our due process. And then the other issue here is whether this was a violation of equal protection. Okay, so now it's a little bit different, but equal protection is saying one set of something was treated differently than another set of something. Right? The law should apply equally to everybody and protect everybody in an equal manner. Well, here what they're saying is that some of these rules were really enforced in some counties. They were less enforced in other counties. And it's weird because in the counties that they were less enforced in, those all went massively for Joe Biden. They all went in his favor in huge numbers. So now they're sort of disproportionately, or I would say unequally, applying the laws to different people. Right? What if there is a law against speeding, but they only enforce that against the red cars? Right? That's not very fair. Everybody else with black cars is going to get around a lot faster than the red cars. It's not fair. Right? But the red cars stand out and there's a reason for it. And so it's not the equal protection of the law. Here they're saying that the election boards, the governors, the people who are running the election, the Supreme Court passed some rules, and then the legislature took those and ran with those unfairly. And then the final question that we have is whether this court has the power, this is an interesting one, to provide a meaningful remedy to the petitioner in advance of January 6th, at which time the electoral votes will be open and counted, or before January 20th, which is the inauguration date that is specified by the Constitution. So they're asking the Supreme Court, guys and gals, do you have the power to provide a meaningful remedy to the petitioner at all? Do you? Does the court? I mean, technically they do. Will they? How will they answer that question? This is kind of a brilliant question, because if the court denies this petition, are they saying that they don't have that power? Is the Supreme Court going to be inclined to divest themselves of some power? You wouldn't, it's like, well, you wouldn't ask the Supreme Court to say, we don't have the power to do that. I guess you could. But in this case, the argument here is that the Supreme Court is going to want to retain the ability to issue a meaningful remedy. They're not going to want to give that up. That's one of their key cards. That's one of their primary functions, is to issue remedies or to decide how remedies will be issued amongst the states, amongst the other various circuit courts. So if they were to respond to this question and say, no, we don't have that power, they're divesting themselves of some power. And big government doesn't like to do that, right? Any sort of entity that's in power, they want to sort of gobble up more and more power, not give it away. So if they answer this in the negative, then they're saying, no, we don't have that remedy. It's sort of like that question, is God so powerful that he can make a rock that's big enough that he can't move it? It's like, that's a good question. Like technically, yeah, but then he can't. And so your head starts spinning a little bit. So, they're kind of asking the Supreme Court here, hey, can you even do this? You want to let us know if you can even grant a remedy? And if you could, would it be a meaningful remedy before January 6th? If you want to say no, then no, but that's your court. That's your position. So I think it's a pretty interesting question. Let's take a look at the underlying cases. So we've talked about some of these. We've talked about Pennsylvania versus boockvar. Looks like these others were sitting in front of the Pennsylvania Supreme Court. So this is in re canvass of absentee. Looks like this was filed November 3rd. This was a November 17th case. This was an October 23rd case. And many of these involve Donald Trump. So his same campaign, Donald Trump for president, versus the Philadelphia County Board of Elections, right? So he's suing the people who were running the elections in the second lawsuit. He's suing the people who were also running the election. So the Philadelphia County Board of Elections, Democratic National Committee, and so on. And then in this last lawsuit, this is the Pennsylvania versus boockvar. We've got boockvar down here. And no, this is actually a separate case. So there's 4 total cases, 3 underlying ones from the Pennsylvania Supreme Court. They go in and they're talking about a couple of the different challenges. So I found a little bit of a different synopsis of those underlying cases. The first case, they're saying on November 3rd, the first lawsuit that they're looking to overturn, they're saying it changed the law to prohibit signature verification on mail-in ballot declarations, and it also eliminated the statutory right for parties and campaigns to challenge mail-in ballots during canvassing beginning on Election Day. So 2 things there. One of the court cases in Pennsylvania that was decided on by the Supreme Court said we're going to get rid of signature verifications on mail-in ballots, according to this lawsuit. And they're also saying that it prevented or precluded the challenge of bad signatures during the election, right? Two pretty big things. And if the Supreme Court did that out of Pennsylvania in that particular case, can they do that? Are they allowed to do that? Because the legislature set a different set of rules. So they're asking the Supreme Court, hey, good or not good? The second case, canvassing observation, eliminated the campaign statutory right to meaningfully observe the canvassing of ballots beginning on Election Day. Seen a lot of that. We've seen that all around the country, basically in every jurisdiction. Many allegations that they're not being allowed to watch or to meaningfully observe. And again, this all goes back to COVID again. The observers, we've played video on this channel. We've talked about it a long time. They're separated out. They're 20, 30 feet, sometimes across the room in massive rooms. Like even at the Staples Center, I think that was over in Fulton County, Georgia, where they had the supposed leak. And then we saw the suitcases come out from under the table and saw some lady, supposedly rescanning the same stack of ballots 5 times and on and on and on, right? The observers in there, by the video itself, were on literally the other side of the room. Like you can't see anything. Is that allowed? Is the Supreme Court out of Pennsylvania allowed to do that? And will the United States Supreme Court let that stand? And number 3, whether this case eliminated or modified statutory requirements for signing, addressing, and dating mail ballot declarations. And we talked a lot about that one as well. We remember there was an order, I believe it was out of Pennsylvania, where the judges were basically saying that as long as it got a certain place by a certain time, we were going to count that ballot. What happened if it didn't have a postmark? So what happened if somebody cast a ballot on the day after the election, but because there's a 3-day window, but that ballot made it into the election's counting tabulation center? Should that ballot count? Well, if it didn't have a postmark, then how do you know? And so there were some rules that were implemented that said, yeah, if you can be reasonably sure that it was mailed before Election Day, before the deadline, we're going to continue to count it. Was that enforced? I don't know. Was the court able to go and do that? According to the Supreme Court, it was. We'll see what the U.S. Supreme Court has to say. In key jurisdiction, the lawsuit goes on, in key jurisdictions across the country, state and local election officials altered or ignored state election laws. And I wanted to point this paragraph out because you can see here, this is their first footnote in the petition. And what they're doing is they're referencing back to a different case. And look what case they're referencing. Oh, there it is. The state of Texas versus the Commonwealth of Pennsylvania, filed in the Supreme Court on December 8th. So they're saying, in key jurisdictions across the country, state and local election officials altered and ignored state election laws, referencing the Texas lawsuit, in which the state of Texas identified numerous provisions of state law that were altered or ignored in 4 key states: Pennsylvania, Georgia, Michigan, Wisconsin. This court denied the Texas lawsuit, and they're saying here, the standing of petitioner is not in question in this case. They're saying you dismiss the Texas lawsuit for lack of standing. Sorry, fellas and ladies, the standing of this petitioner is not in question in this case. So it's hinting here that they're going to be renewing a lot of the same arguments and a lot of the same allegations that were already filed. The Supreme Court threw that one out on standing. What are they going to do with this one? What are they going to find here? How are they going to throw this one out? Let's go back. It says, in violation of the federal Constitution, Article 2 assigns state legislatures authority over the manner of choosing electors. We've already talked about that. And they're also referencing this statement from Judge Alito. And it's something we talked about here before the election. So once again, there was this Pennsylvania lawsuit, boockvar, that worked its way up to the Supreme Court. Supreme Court split 4-4, denied hearing the case. So that means the lower court rule stands, sent that back down to the Pennsylvania Supreme Court, basically affirmed it. So that ruling held. And in that decision, 3 people in the conservative camp on the Supreme Court said, no, we would have heard that case. The one where John Roberts joined the liberals, which split the court. They said we would have heard that. If John Roberts would have joined with the conservatives, remember, it's a 4-4 court. So if it would have been a 5-3 with 8, this case would have been dealt with. This issue would have been heard by the Supreme Court. But because Roberts joined the liberals, 4-4 went back down. Now it's coming back up. And in that decision, Alito said, this is a problem. We pointed that out before the election. All right, let's take a look. It says, and this is his dissenting opinion. He says, the constitutionality of Pennsylvania Supreme Court decision in Pennsylvania Democratic Party versus boockvar. And you can see here, the Democrats sued boockvar. Okay, the Republicans didn't initiate this lawsuit. They did. And they're saying, Alito was saying this has national importance. Remember, this was written before the election. It has national importance, and there is a strong likelihood that the state Supreme Court decision violates the federal Constitution. Right? That's what Justice Alito said. And they're saying this case presents in stark relief several of the violations that occurred in Pennsylvania. Together, those violations alone affected more ballots than the current margin of difference between the two principal candidates for president in Pennsylvania. So, right, one of the Supreme Court judges who's joined with Judge Gorsuch and Justice Thomas, they both were already saying this is going to be a problem, as we're finding out. We were talking about this well before the election, and now it's back at the Supreme Court. It goes on. So that was more, let's say that was more of a I told you so type of a thing, right? We knew this was coming back up. The Supreme Court has already hinted that this is a problem. Now what they're going to talk about is this separation of powers argument. So this is one of these constitutional provisions. I just want to hit on this quickly, and then we're going to go into the mootness and the standing argument because there are some interesting things there. All right, so back into the constitutional and the separation of powers argument. This is what they wrote in their petition. It says, in October 2019, the legislature decided to allow no excuse mail balloting by any eligible voter in the state. That was 25 under PS, which is probably Pennsylvania statutes, section 3150.11b. Okay. And the legislature passed that, but it retained the strict signature verification, voter identification, and observation and challenge requirements. And you can go and you can look at section 1302.2, 1306, 1308. It was all part of Act 77, which we've talked a lot about. Those requirements were in place and complied with in the delayed June 2020 primary election. So follow along. The state legislature in 2019 passed a law that was in effect during the primaries, but unfortunately, each of them was dispensed with for the general election, not by the legislature, which is required by Article 2, but by the state and local election officials, either unilaterally or in conjunction with the state's elected Supreme Court. Right? You can just follow along on that. The Constitution says the legislature is responsible for passing the election rules. In Pennsylvania, October 2019, Pennsylvania passes no excuse mail-in balloting by the legislature. There's even some argument, however, that Act 77 itself is unconstitutional because it wasn't an amendment to some other mail-in balloting requirements that are in Pennsylvania's Constitution. And I think you can make a very good argument that the entire Act 77 is unconstitutional. But let's not even play that game. Let's just say, okay, it's fine. The legislature passed it. Therefore, we're going to give it some merit. It's better than the courts passing it. So the legislature did it. Great. Let's at least play by those rules. However, Act 77 was, I think, unconstitutional. That being said, all right, enough. Legislature passes it. They use the legislature rules during the primary elections, signature verification, voter ID, observation, challenge rules, all in place, no problems. The primaries are over. General election comes up. Prior to the general election, we have a whole slew of rulings by the Pennsylvania Supreme Court, which changes all of those things. So the Supreme Court now steps in, divests the legislature of some of their power. Are they allowed to do that? Can you continue to do that? We're going to see what the Supreme Court has to say. They addressed preemptively the allegation that this is going to be moot. So the Democrats are going to respond. Kathy Boockvar is going to respond. Probably going to be a lot of other intervenors unless the Supreme Court just throws it out quickly. But they are addressing this mootness and this standing and some of these other technicality issues in the hopes that the Supreme Court will hear the case. In the lawsuit, they say the issues addressed by this petition are not moot. They're not moot. Respondents, who's going to be Kathy Boockvar and her company or her team, they may contend that these cases are moot because the certified electors already met. They cast their votes for president. They transmitted those votes to the president of the Senate. and as specified by federal law under U.S. Code Section 7 and 11. But in Pennsylvania, as well as 6 other states, 2 different slates of electors met, cast votes, and they transmitted those votes to the president of the Senate. And this was pretty neat to see, this Ivan Penchikov. We've talked about him a lot. He's over at the Epoch Times, and he's sort of made a little bit of a name for himself over this last election. And it's very, very cool to see his name now in a Supreme Court brief. So kind of a thumbs up for him. I mean, I've been following his work for some time, and now he made it into a Supreme Court brief. So pretty cool. So they're referencing him. They're saying electors in 7 states cast dueling votes for Trump. And that's his article that he wrote on December 15th, probably, which I read. So what you can see they're saying here is that we're going to be, this thing is still hot. Okay, just because they cast their votes doesn't mean that this issue is over. And specifically, they're referencing sort of this dueling electors that, we saw this, we covered it on the show. We had pictures or I think video of people out in Nevada who were literally casting their ballots on the side of the road. They were right in front of a government building. And there were some other indications that other people were not given admittance into government buildings. And what happens now? What happens when you've got, a set of people voting, electors who were nominated by their local governments to go and cast these ballots or these certificates of ascertainment to cast their votes for the president on behalf of the Electoral College? Now they're casting their ballots, but the governor just certified another set for the Biden people. Well, what the heck is going on here? How does this work? How does this make any sense? So the lawsuit addresses it. They're going through and they say, listen, this has happened before. All right, everybody calm down a little bit. Here's how it works. They're saying, though rare, a thing like this has happened twice before in our nation's history when election challenges such as this were still underway on the date Congress had designated for the electors to meet and vote. In 1960, Hawaii's governor had certified Vice President Richard Nixon as the winner of that state's electors. Those electors met on the designated day and they cast their votes, but because challenges to the results of the election were still pending, the electors pledged to Senator Kennedy also met and cast their votes. When it was subsequently determined that the Senator Kennedy had won the election, those electoral votes were the ones counted during the joint session of Congress in January 1961. Right, so it's pretty simple. Right, they just the litigation was pending. Presumably, they got an answer on that lawsuit. Kennedy won. They counted Kennedy's votes in January 1961. It's not January yet, so both of those ballots or both of those slates of ballots from those electors were valid. It looks like, until they were actually accepted in Congress on January 1961. Similarly, the election of 1876 likewise yielded multiple slates of electors from several states, namely Florida, Louisiana, Oregon, South Carolina. The legal challenges that swirled around that election dispute were only deemed moot once a commission established by Congress determined that Rutherford B. Hayes had prevailed, and then only after he was inaugurated on March 4th, 1877. This case will therefore not be moot until at least January 20th, 2021, the day the Constitution now sets as Inauguration Day. So you see how they're kind of moving it even back beyond January 6th. We've been saying this a long time. The posts are going to continue to move. We talked about it December 8th, December 14th. Now it's sort of January 6th. Now they're saying we can even continue to litigate this thing all the way up until January 20th. And their rationale for it, the basis for this, is this argument. It says here, none of the other election dates, such as the so-called December 8th safe harbor date established by the U.S. Code, or even the January 6th date for the joint session of Congress, are constitutionally required. Indeed, if this court vacated the state's appointment of presidential electors as having been illegally certified because of illegal and unconstitutional conduct, those electoral votes would not be counted as part of congressional joint session. Even, and this is interesting, even the swearing in of the next president on January 20th will not moot this case because review could outlast the selection of the next president under the capable of repetition yet evading review doctrine, which applies in the context of election cases when there are as applied challenges as well as a more typical case involving only facial attacks. And so what they're saying here is that, look, all right, even if, and I'm in agreement with this, even if Joe Biden is inaugurated on January 20th and unloads his U-Haul van and all of Hunter's stuff into the White House, then on that date, they're saying this is still something that needs to move forward because it is capable of repetition, but it evades review, right? And it's the same point I've been making on this channel for 6 weeks. We want to know what happens when this happens again. How do we prevent this from happening again? And look, whether you say that there was legitimate fraud or not, a significant portion of the country believes that there is. Rasmussen over this weekend, I think, said something like half the country is now of the belief that this thing was fraudulent. And we don't want that to happen again, right? We need to shore up our election system so that we're not even having these discussions or having these arguments the next go round. So we're hopeful that the Supreme Court will grant the petition for a writ of certiorari. I'm not holding my breath on that, but I would like to see it. And I would like to hear more if there is a denial. If Judge Alito, Gorsuch, Coney Barrett, Thomas, all of them, if they go and they deny this thing, we need a little bit more than a little bit of a paragraph. Because in my mind, anything less than accepting this and giving us some clear guidance is going to result in additional malfeasance, more fraud the next go round. Both sides are going to try to out-cheat one another. It's going to be a litigation bloodbath every election because they're all going to be trying to change the rules and game the system. So we're hopeful that they do grant the petition. We'll see. We'll follow along. Make sure you subscribe because there's going to be a lot more on this story, hopefully. And if not, we'll talk about the denial as well. All right. So enough of the lawsuit stuff. That's a lot of text. I know eyes can kind of glaze over when we go through some of the heavy litigation, but it is important because there are some good arguments in there. Let's change gears a little bit. We want to talk about this new massive spending bill from the federal government. This comes from Fox News. Congress unveils a massive $900 billion COVID government spending bill after months of negotiations. This deal comes at an increasingly perilous time for the nation as it teeters on the brink of another economic turndown. So you probably have seen some news about this around the news. And, this is one of those things that really makes you appreciate how kind of useless the government really can be. Let's break this down a little bit. Congressional leaders on Monday unveiled a mammoth agreement on a roughly $2.4 trillion spending package that includes $900 billion in coronavirus relief after half a year stalemate. So they've been duking this out for about 6 months now, securing another tranche of aid as a surge in COVID-19 infections threatens to further derail the nation's faltering economy. The House is expected to move swiftly to pass a bill on Monday night. That's tonight. Senator Majority Leader Mitch McConnell pledged that lawmakers won't leave the Capitol until the bill is passed, giving lawmakers and their offices just a few hours to review the massive 5,593-page bill. Okay, so they unveiled it today, and they got to read it today. 5,593 pages. Is anybody going to read that? Is anybody going to read 100 pages of those? All of these Congress people? So they're all going to unveil a bill, read it, sign it on the same day, and it's got 5,500 pages of material in there. Well, we're going to go through it because Twitter, we're not going to go through 5,500 pages, that's for sure. But Twitter showed us a couple things that we need to point out. So let's take a look at what is in there. If Congress fails to pass the bill or another temporary spending measure, a government shutdown would begin tonight at midnight. Here is what is inside this thing. This measure includes $325 billion in small business relief, including $284 billion in forgivable loans for small businesses through the Paycheck Protection Program, which we've got an unextended boosted federal employment benefits. We got $300 a week now going through March 14th. We've got another $600 stimulus check, which is going to Americans who are earning less than $7,500 or $75,000. So if you're earning less than $75K, congratulations, you're getting a whopping $600 check. Never mind that your cities have been closed. Most of your venues have been closed. Many of your businesses have been closed. Mine has been closed. They basically, we were an essential business. We had to, implement all of these protocols, spend a bunch of money, do all of these things to lock down. Fortunately, we didn't have to let anybody go or anything like that. But, the people who we're in an okay spot, but the people who really need it, they can rest assured now because they got $600 coming. coming in hot. Don't spend it all in one place there, folks. Treasury Secretary Steve Mnuchin said Monday he expects the federal government to begin issuing checks to millions of Americans as soon as next week. Yay, great. The legislation addresses dozens of other issues: $45 billion for transportation, $82 billion for schools, $20 billion for vaccines, $13 billion for food, $25 billion in rental assistance. It also extends an eviction moratorium for CDC, from the CDC that was poised to sunset at the end. So good. At least they're going to let some people stay in their homes. That's nice. The legislation notably excludes two of the thorniest issues which have plagued negotiations for months: funding for state and local governments and a liability shield for businesses against coronavirus-related lawsuits. So that means, if somebody comes into your establishment and they catch the coronavirus, even though they can't prove where they got it or where it came from or any of those things, they can just start suing small businesses. Okay, that sounds good for the country. Let's go on. Let's see what Ms. Pelosi has to say about it. Here is Nancy.
We also have in the legislation direct payments, which were not in the Republican bill, to America's working families. I would like them been bigger, but they are significant, and they will be going out soon. We also...
All right, so a significant one-time $600 stimulus for American working families. Isn't that nice of our lovely government? I wonder how many of them have gone without a salary or have had to close their businesses. Has Congress been closed? Have they been forced to stop anything, stop their travel, stop their trips abroad, any of their pensions, any of their health care, any of this stuff? Has that been also stopped like yours has? Probably not. In fact, here's what they make. So here is Speaker of the House, Nancy Pelosi. She's making over $200,000, $223,000. It's pretty good. If you're a regular House or Senate member, you're not in the majority leader or minority leader, you're making $174,000. So pretty good. So certainly they're not going to get the $600 check. Oh man, they're cutting themselves out of that $600 stimulus check, which is, it's hard for them. It's a hardship. They're going to have to go without, tipping their hairstylist this holiday season, but they're going to make do. Let's see what is really in the bill. So while you're lavishing at home, sitting, waiting for that $600 check to come through, which is look, that's great. I'm happy that the government is, they'll take tons of taxes from you, taxes your whole life in every single way that you can think about it. Sales tax, property tax, every time you hop on a plane, 9/11 million taxes here. You've got water tax. Every time you do this, everything you go, plus the income tax, you die, you get, stuff, everything is taxed ad nauseum. They're going to take. But when you need something, they're going to cut you a pittance of a check. $600 is coming back to you, which is good. But let's see what else is in the bill. What are they doing for the rest of the world? Because, of course, America is not just America. America is a global provider of Lord knows what. Here is what else is in the bill. The Economic Support Fund. So Twitter was... Twitter all afternoon, combing through this 5,500 page monstrosity of government malfeasance. And what we see here is that $700 million for Economic Support Fund, that's going to be going on over, it's going to be available, let's say, until September 30th, 2022. This is going to be the assistance for the Sudan. Which may be made available as contributions, provided we got $100 million of funds. They're going to be transferred to or merged with funds made available to the global health programs and the transition initiatives in acts making appropriations for the Department of State. Okay, so it looks like $700 million going on over to the Sudan. We've got some more information here. The funds are appropriated. They're going to be headed to make contributions authorized for agriculture, economic growth programs, and so on, all over in the Sudan. What else do we have in this beautiful government bill? Well, it looks like $134,950,000 are going to be made available for the assistance of Burma. Okay, of all the funds under the heading of this, that such funds are going to be made available notwithstanding any other provision of the law following consultation with the appropriate congressional authorities, provided further that you see what they do. They're just throwing in huge buckets of money and they're not even telling you where it's going. It's just made available. $134 million is going over to Burma. We go over to Cambodia. Never been to Cambodia. Don't know anybody in Cambodia. I'd have a difficult time finding Cambodia on a map. But they're getting $85 million. $85,505,000 shall be made available for the assistance of Cambodia. All right. What else is going on? Surely it's more than that. We've got, looks like a lot of money is going over to the Indo-Pacific Strategy and the Asia Reassurance Initiative Act. So not less than $1.482 billion with the B is going to be made available to the implementation of the Indo-Pacific Strategy and the Asia Reassurance Initiative Act of 2018. I have no idea what that is or how that helps anybody in the United States who's got COVID or suffering from COVID or been impacted by COVID. No idea. But we're sending $1.482 billion over to, looks like someplace over in Asia. We have some more funds going over to Nepal. Another $130,265,000 shall be made available for assistance to Nepal. What is that for? For development and democracy programs. You have any idea what that is? I don't know what that is. Development and democracy programs. It sounds like to me, probably like $130 million is going to be thrown into a slush fund that all of these different members of Congress are going to be able to go and use and extract money from. And they're going to be able to go and make decisions about what happens there or, point their fingers towards this person gets that contract and I'm a consultant now, or I'm going to, leave Congress and I'm going to go be an international consultant and I'm going to go enter into, different agreements here, like for oil companies or for gas or, deals with China, whatever it is. And, speaking of that type of activity, how much money is the Ukraine getting, right? We talked a lot about some people who have been entering into deals with different foreign countries. What's the Ukraine going to be getting here? Oh, yeah, there it is. $453 million is going over to the Ukraine. It's going to be made available for assistance for the Ukraine. What the hell is that for? I don't know. Apparently, the Ukraine needs a lot of that American money in order to survive. I don't know. I don't know what it's for. Neither do they, apparently. And we also, look, everybody's on the list. We even have $500 million that are going over to the Israelis. Look at that. We got $500 million shall be for the Israeli cooperative. So what is this? That amount, we got $73 million of that is going to be for the Secretary of Defense to provide for the government of Israel for the procurement of the Iron Dome system. We've got another 177. It's going to be for the $177 million for the short-range ballistic missile defense program. Another $50 million. It's going to be for the co-production of activities for the SRBMD systems in the U.S. Another $77 million for upper-tier component of the Israeli missile defense architecture, of which $77 million shall be for co-production activities and so on, right? So massive spending bill, $500 million to the Israelis, $400 million to the Ukrainians. We've got Nepal's getting money, Burma's getting money, we've got Cambodia's getting money. Everybody's getting money except you, the American people. You're getting $600. Good job. You've been paying into that tax program for your entire life, essentially. Every time you purchase anything, you're paying some sort of tax. Every time you take a paycheck home, you're paying the government something. All of that money funneled right out of the country to other people, even though there are millions of Americans who need it here at home. That's our government for us, folks. Isn't that great? This type of stuff boils my blood so badly that I ask Miss Faith to help calm me down a little bit. So at the last slide, we're going to just transition into a peaceful, serene slumber and just take a deep breath and let's talk about the Christmas star. All right, folks, this comes over from refinery29.com. We're going to get a little bit woo-woo here. This is the Great Conjunction. It's almost here, and it's going to change everything. This past month may have felt a little bit different for you, right? Things appear to be shifting. I think I know why. On December 21st, which is today, Jupiter, the planet of luck, and Saturn, the planet of authority, are gearing up to meet in Aquarius in a very rare astrological event known as the Great Conjunction. The powerful placement, which happens to coincide with the winter solstice, marks the beginning of a new era, one that may finally usher in some much-needed optimism. We could all use a little bit of that, right? And so that is taking place tonight. If you go outside and you look at the sky, you're going to see Saturn and Jupiter in very, very close proximity. And so I want to encourage you all to do that. I will be doing that here shortly. These two planets seem to cozy up in the night sky every 20 years or so, but this year they will be super close, like closer than they've been since 1623. They meet at 0 degrees Aquarius, a placement that relates to starting brand new cycles, according to this fellow right here. And from our vantage point, these two bright planets will appear as a single glowing star because of this and the timing of the celestial event. Many are calling this the, quote, Christmas star. So that is taking place tonight. If you have not seen that, in the news. You may want to go out and check that out. Miss Faith also had another little clip here. She says, it has been said that this cycle is considered the ground base of human development, which marks the interaction between the perception of ideas, potentialities, and the manifestation of ideas in the concrete material world, which is very interesting, right? Now we're at sort of wrapping up the year, and we all are reflecting on what that looks like and thinking about what 2021 is going to look like. And it's been a hell of a year. So we've got a lot of, I think, optimism looking into the future, because how can it be much more challenging than 2020 was? And for some people, it was a little bit of a moment to sort of level things up, right? To see if you could weather the storm. And I hope that you did. One final quote over here from Miss Faith says, if you have something that you want to begin, that you're deeply committed to, and you're willing to work really intensely at it, and that you want to do for a long period of time, this is the time to initiate something in that regard. So it's a good time. You know, we had a big office meeting here today where we were getting sort of all of our director heads together, and we were thinking about what 2021 looks like. We put a plan in place. Everybody sort of presented their ideas, and we're pretty excited about it. So I just wanted to call that to your attention. You know, now's a good time maybe to take a step back from some of the politics, some of the legal news, some of the news in general, and start thinking about what you want out of 2021. I know I'm going to be doing that for the remainder of the year, and I will be also looking at the Christmas star tonight, and I want to encourage you to do that as well. You know, it kind of helps put things in perspective when you kind of step outside of your home, turn off, get away from all the electronics, just go stand outside for a little bit. Look up there, you're going to see Saturn, you're going to see Jupiter together, you're going to see the Christmas star, and maybe think about, with some intention, what you want 2021 to look like. I don't know if it's going to work, but I'm going to try it. I think that it will. All right. So thanks for indulging me on that. Let's take a look at some of the super chats. We have, okay. So super chats coming in. This comes from Eliezer R. Says, I believe there are mainly 6 counties in question on voting fraud. Why not seize those ballots and counting machines from those counties by any means possible manually to confirm the fraud? Well, it's because we live in a country of laws. I know it's a good question. Thanks for the support there, Eliezer. You know, it's a country of laws, and unless you wanted to just deploy the military to go in and seize those things, you need court orders. You got to go through subpoenas. I mean, there's a reason we have the Constitution. There's a reason we have property rights. There's a reason we have, the amendments that protect us to be free from searches and seizure, preventing people from coming in and taking our things. And even though people are hot and heated over this election stuff, I don't want to violate those principles. I don't want to suspend the writ for habeas corpus. I don't want to authorize warrantless searches and seizures. We don't want to go that route, because the underlying premise, the constitutional obligations that we have been following for the entirety of our country, those are more important than going in and seizing machines and things like that. I think there are other ways to do it. And largely, I think it starts with the people demanding more from their state legislature and fighting this battle on the ground, right? On the ground floor, by going in and rallying more support to put the right people in the right offices to really recreate our electoral systems. I think that's a better approach, not going in and starting to seize things, because that is just something that can get worse and worse and worse. Good question, though. Thank you, Eliza. He says, Matthew Riley says, I want to meet you so bad. I know you're busy, so I'll do something the Popo say no, so I can see you on your job. See you there. Oh, gosh, that is hilarious. Yeah, I'll do something the Popo say no, so I can see you on your job. See you there. Do not break the law, all right? Nobody break the law out there. Cannot endorse any criminality of any type on this program, Matthew Riley. And if the universe is meant to be our paths, I'm sure we'll cross, my friend. Thank you for the support and for the funny super chat. Appreciate that. We have Mr. Fang says, has anyone declared they will object at the inauguration? And then another one in the super chat. He said, I couldn't fit my question into the super chat, but I meant to ask if anyone has officially said they will object during the reading of the votes. Thank you, R and T. Maybe R and F for Miss Faith, but good to see you, Mr. Fang. Thanks for being here. Thanks for the support and the good question. Yes, some people have indicated that they will be objecting. Now, what I have seen thus far is not a senator yet. We have seen that Matt Gaetz, I think, is a House representative, has confirmed that he will. Mo Brooks has confirmed that he will, but that's about it. I think that we're probably going to see a number of people in the House that will do it, but whether they can get a senator, and they need a senator, whether they can find somebody who will, we don't know. Senator Tuberville, who's a senator-elect, he has sort of hinted that he would, and then he walked that back pretty quickly, like the next day. And so we don't know what he's going to be doing. We don't know whether Rand Paul's going to do anything or anybody's going to be willing to join them. But there's still a little bit of ball game left to play between now and the 6th. So we'll see. Good question there, Mr. Fang. We have Wolfgang Deo, who's in the House, who says, what specific facts were agreed upon before the Texas SCOTUS suit? I think they could redo everything at this point with that from the grounding and do an Xmas live stream with your mom. Yes. So Wolfgang is in the House. I don't think that they agreed upon any facts prior to the filing of that petition for a writ. I did not see that in there. If there was when two parties agree on a certain set of facts, they'll call it a stipulated set of facts or stipulated statement of the facts. And I didn't see that here. I think they're arguing about just about everything. So don't know that I don't know that the response from the Democrats is going to be like, yeah, we agree with page 1 through 7, but the rest of this stuff is nonsense. They're going to go through and object to every single thing, contest every underlying fact, as they should, right? They're opposing the motion. Wolfgang Dale on doing a Christmas live stream with your mom. Good question on that. My mom is cooking. She cooks for like 2 weeks around Christmas. I don't know that she's going to have any energy left after feeding everybody, but I will ask her. I'll certainly ask her, and she may make a cameo. Was it cameo at some point in time? We'll see if she's around. Thanks, Wolfgang. We got Cheryl Myers, who says the Michigan legislature rescinded governor's emergency power law. Could they also rescind laws giving delegates to popular vote winner? Does the governor have to sign? So yeah, so they could. Yeah, they could. The legislature could pass whatever laws that they want regarding the election. Really, the votes that we do are nice, but they're not required. We can all go vote, but we don't, the government doesn't have to give us the power to vote. That's why we have the Electoral College, and the legislature can conduct that however they want to. The legislatures across the country unanimously have given the power of the vote to the people, and they're saying we're going to honor what the people want, but that's not mandatory. So people say that, this is a democracy, and it's not really, right? It's a democratic republic. It's a republic because we elect representatives to go and do things for us, and that includes voting for the president. That's what the Electoral College is. So if the legislatures wanted to revisit that and change the course of the election, they theoretically could do that. The governor, I do believe, still has to sign that, but I think there's probably a good argument that maybe not even, right? Because it's what they did. I think it depends on the state. It's a good question, Cheryl Myers. And that's the same argument that Rudy Giuliani and Jenna Ellis have been making for a long time. They're asking the state legislatures to take it back. Let's see. Wolfgang Deo says, time to strip back administrative law. Yeah. I'd rather just get rid of a lot of the administration. Then we don't need so much laws around them. We have Charles Reed, who says, so if Big Gretch Rona orders, oh my goodness, orders are considered unconstitutional, would that not cover the way the election was done as a result? As well, making the election changes also considered the same. Oh my goodness. So I think you're talking about Gretchen Whitmer from Michigan, the Big Gretch Rona. Oh my goodness. All right. So if her orders are considered constitutional, would that not cover the way the election was done as a result? Yeah. So we've talked a lot about Gretchen Whitmer on this channel. She was going to get abducted by 3 or 6 individuals who just got indicted. And she issued some COVID restrictions that were deemed unconstitutional. And then she did it again anyways. And so the question here is, if she's passing all of these unconstitutional arguments or all these unconstitutional rules, just running with them, wouldn't that obviously apply to what they did with the election? And there's good arguments there, right? There's been a lot of lawsuits out of Michigan, and we just haven't seen any of them taken up. I mean, I've made the argument that a lot of these types of sort of overstepping of the boundaries by one branch of government across another branch of government, I've said that in my mind, those are clearly unconstitutional, right? And for good reason. There's a purpose behind that. It's called checks and balances, right? We all learned about this in social studies and civics class in like 3rd grade, but apparently the courts have forgotten about it. You want the 3 co-equal branches of government. You want a separation of powers with checks and balances, because they knew that one branch was going to encroach on the other one. And it's the branch who's being encroached upon. It's their duty to push that other government back and say, nope, that's our purview. You don't get to step in here and tell us how to do things. And I'd like to see more of that, not less. Thus far, the courts have just said, yeah, do whatever you want, literally. Big Gretch Rona, if you want to go in and just start doing whatever you want, we're going to deem it unconstitutional. You can just do it anyways. Nobody's going to do anything about it. It's unfortunate, which is why the Supreme Court could shed some pretty nice light on it. We have Joel Lowry, who says, regarding the specter of civil war, if you've listened to Biden's gun confiscation plans and Oath Keepers founders already denouncing such threat, doesn't this seem that civil war is on the horizon? So, Joel, I've seen a lot of that type of talk. To me, I'm not particularly concerned about it, honestly. I just don't think that we're there. I really hope not. I hope that I'm correct about that. I hope that I'm not wrong about that. I don't think that this is something that necessitates any violence or any secession or anything to that extent. I think that the better answer is to play within the system, and elevate the good people who are asking the right questions and doing the right thing. If we can rally around those people, those candidates, those people, talking about these issues, championing a cause in that way, I think that's more effective than saying we're going to leave the country, right? I don't think that that's a realistic remedy anyways. I don't think that would actually happen. If there were a civil war, that would be a huge problem. And I don't want to see that. I don't want to see bloodshed. I don't want to see, people killed over this election stuff. I would like to see a lot of people thrown out of office for sure. I'd like to see a lot more people voting. I'd like to see a lot more people get more civically minded, get a reconnection with their founders, understand why this country works and how it works, and learn a little bit more about the American culture and think more critically, not just gobble up and consume everything that they see on CNN and Facebook and believe whatever Twitter tells them to believe. If we have more people thinking critically, that's better for society. It's better for our entire country. And that, I think, is the more productive route. But I understand what you're saying. If they start taking guns away from people, there's going to be a response to that. And what Trump and his people are talking about is, I think that, right? There's a huge portion of Americans who are very unsettled right now, and there may be a response. Now, I'm hoping it's not violent. I'm not encouraging that at all. Not at all. Not at all. I disavow violence across the board. But when people are painted into a corner a little bit, backed into a corner, stuff goes wrong. We don't want that, though. Good question, Joel. Thanks for being here. Thanks for the nice super chat. Appreciate it. We have Brian Reinhardt, who says, if Trump doesn't have standing, then who does? It's a good question, Brian. I agree with you. I would think of anybody who has standing, he has standing. We're going to see what the Supreme Court does with that. We have Joel Lowry, who says, great work, by the way. Post to the Donald.win forum to get your show out since YouTube screws your A. Joel, I would love, can you post it over there for us? I feel so terrible sort of promoting my own stuff over there. I do like the Donald.win. It's hilarious. Okay. Even if you're not a Donald Trump supporter, they are so clever. And there's this meme going around that the left can't meme. And if you look at the Trump memes versus the left memes, I agree with them. They're just clearly better. And the Donald.win is a good place for them. It's kind of like going to, I don't know, like a carnival to a certain, like a rally. It's like a rally. It's like a 24/7 rally over there. It's a lot of fun. Head on over to the Donald.win if that's your forte. All right, we got a couple coming in with no questions. We have Tom Cristiano and we have Ivan Ramirez with a couple nice super chats. No questions. Thank you both for the support. Another one from Wolfgang coming in says, if power of election is held by the legislature, then neither the voter integrity nor suppression matters if they want it to amend the Constitution. Yeah, I mean, I can see where you're going with that. You're saying that if the legislature can just do whatever they want, then they can authorize holes where you can drive a suppression truck through it or a voter integrity truck through it. And they can create a system that they can exploit. And I think that's true. I mean, I think, one of my points here has been that does anybody really want to fix the election system? Because why would they? If they both know how to play in the system and there's sort of an incentive to create a gray, messy system with a lot of mud in the waters, and you have people who make their money doing those things, like the pollsters, the election consultants, the get out the vote people. I mean, it's a multi-billion-dollar industry. They have sort of a perverse incentive to keep things the way that they are because they know how to run that system, and they're getting better at it. Right? Mark Zuckerberg donated, $400 million. Priorities USA funded lawsuits in 7 different states. We've talked about many of those lawsuits. They are getting very good at this stuff. So why would they really want to change anything? They just won. They just crushed the Republicans. Why would they want to change that system. And where are the Republicans asleep at the wheel? They're not doing anything else to respond to it. They're just saying, yeah, you're right. We lost. Sorry. Next game. We'll see you next time. Do you think the Republicans are going to win the next time? I don't. Another one from Wolfgang says, regarding the vaccine distribution talk, isn't it a violation of equal protection that the CDC specifically addressed race as the number one deciding factor? It's a good question, Wolfgang. This is a spicy meatball. You just asked me right here on the program. I'm going to answer it. And this is probably not a good legal question, because I think you're right. If you do make the argument and you say, hey, we're going to prioritize one group of people over another group of people, you could make the argument that that is a violation of equal protection, right? You could say that here it looks like non-whites are getting more of a preferential treatment than whites, right? Isn't that a violation of equal protection? I think technically you could make that argument when you start going through some of this stuff and you analyze it according to what's called basic government scrutiny. What level of scrutiny are you going to apply? I think the government can make a very good, compelling argument that this is necessary, that this is so strict scrutiny is a compelling government. It's necessary to achieve a compelling government interest. So let me back that up a little bit. I had to remember back to my constitutional law. When the government does something that infringes upon somebody's, a very important right, when the government acts in a way that infringes on your rights, the government the courts will ask the question, is what the government doing, is it necessary to achieve their goal? So necessary is one. Is it necessary? And is it to achieve a compelling government interest, right? So here you would say COVID is important, right? We got the government has a compelling interest in making sure that COVID is dealt with appropriately. And is it necessary to do this? Yes, we have only so many vaccines. We can't give everybody one. Eventually we will be able to, but right now we do not. So how do we mitigate COVID? What is the least restrictive thing that we can do to not infringe on people's rights? And it's necessary to achieve a compelling government interest. Well, the least restrictive thing that they can do is to just, arguably hand it out to the people who they want to prioritize, because what that is going to do is mitigate the harm that is endemic to the healthcare system. So I think that is the best argument. And you could say, all right, well, listen, if African Americans, Hispanics, whatever the CDC is talking about, if they're saying they are more adversely impacted by the coronavirus than, white male Caucasians, I'm okay with that. Truthfully, I'm okay. I'll say, all right, that's fine. Because what happens is, think about this just practically. If one segment of the population is really hit hard by the coronavirus and they all get hospitalized at a higher rate, so in this case, let's talk about African Americans. I think they have a very high difficulty with the virus. It just impacts them differently than some people. I've read that it impacts people with certain blood types. There's a new company that is now testing people's DNA, and they can find sort of alleles and genetic markers where they're saying, yeah, you're more at risk for COVID. So I would even be okay with that. Like if everybody wanted to get genetically tested and we say, okay, this group of people have a much higher exposure rate or a much higher, let's say, mortality rate. If they catch it, they're going to end up in the hospital. They're going to be on the ventilators. They're going to be on, it's catastrophic for them. I would clearly support those people getting the vaccine sooner than other people. And if currently we're breaking that down by race, I'm okay with that, as long as the data shows that would help the healthcare system more than vaccinating people who aren't going to get sick or who aren't going to die from it. Right? My hope is here that I'm healthy enough. I take care of my body. I don't have any comorbidities. I'm not a high risk COVID person. I'm 35. I'm young, pretty physically fit and healthy. So I'm okay with the government putting me into that bucket and saying, yeah, this he can wait a little bit. Right? I'm fine on that. But I can understand the tension here, right? The tension of one demographic versus another demographic. And so I think there is a good equal protection argument, but I think it's overcome by just saying, look, it's the best thing we can do. We're going to get everybody eventually, but right now it's necessary to achieve a compelling government interest. And I think the courts would probably uphold that. We will see if anybody challenges it, though. Good question. Very good question. We have Shiraf Morgan, who says, you are the bomb. Just love coming home after work and sitting down to watch you and learn the latest. Thanks, Shifra Morgan. I appreciate that. I appreciate you being here. Love the super chat, and hope to have you indefinitely. Thanks for watching. We have another one from Jenny Wren, who says, you are amazing. Thanks, Jenny. I think the same about you. I appreciate you being here, and that's a very nice super chat and a very nice emoji. So thanks for that. We have another one coming in from Dr. EMB. Dr. EMB always throws in just monster super chats. And she's asking the question, says, will the defendants have to respond to SCOTUS why all these shenanigans happen? I.e., why did the cardboard go up to block out the view? Why were poll watchers locked out? Why did votes come out of the suitcases and duffel bags? When are they held accountable? It's a good question, Doctor. And I don't think that, unfortunately, we're going to hear any answers on any of those questions because they're just not going to answer those. They're just not. They're just going to say, all right, these are the underlying claims. So they go through. It's sort of like a call and response. So, Donald Trump makes these allegations. They're going to respond directly to the allegations. Now, your questions I think are very pertinent, but they're not something that is going to be consequential. So let's say, for example, the question comes up, why they put cardboards up to block the view. All right, well, where did that happen? One tabulation center. All right, so if let's say that was true and they were violating the observation laws and all of those things, what are we going to do with those votes? We're going to throw them out? Right. So you have to find issues where the harm match or where the remedy that you want matches the harm. And largely what a lot of these claims are to you and me, to an outside observer, we can all see is, okay, that adds up. This adds up. This is weird. These bellwether counties, there was a red wave. There was, all these lawsuits, litigation was across the country going on so that they could modify the rules. And, to us looking at the big picture, yeah, it's pretty clear that this thing was highly, highly problematic to say the least. But the court is going to look at every one of those questions, every one of those claims and say, of what consequence is that question? If we know why they put cardboard up, is that of consequence? Or can they just come back and say, well, it was because we were afraid they're going to throw things through the window? All right, well, that's a reasonable explanation. Next question. Why were the poll watchers locked out? Well, they're going to say, well, we already admitted 3. That's the limit. There's COVID restrictions. And so they're going to find a justifiable reason for every one of those. So what you're seeing now is sort of an abandonment of a lot of those questions. Now it's going back to the constitutional issues. All right, fine. You don't want to hear about our affidavits. You don't want to hear about our observers being thrown out. You don't want to hear about, me watching them just, look at signatures that were just a squiggly line, not matching anything. You don't want to hear about that. Remember, we have hundreds of affidavits from all over the country, from many people in various states that we've seen on camera. They've signed sworn statements under oath, under the declaration of, a penalty of perjury, declarations, affidavits all over the place. Courts don't even care because all they're doing is they're just connecting it to a plausible explanation, right? Why did votes come out of the suitcases and duffel bags? You ask. Oh, well, those weren't suitcases. Those were just legitimate ballot containers. Why were they under the table? Well, that's where we put them, to put them out of place. Well, why didn't you put them all over there? Well, why did you kick all the observers out? Oh, we didn't kick them out. No, they misheard us. They were just going home because their part of the job was done. Okay, well then why did they come back at 1:30 in the morning, hours later? And who was that guy who took a phone call and suddenly realized, oh wait, we're counting all these things without any observers? And then who decided to call the observers back and continue counting? Nobody asked those questions. They just find justifiable reasons for the basis of the underlying claim. That's all the courts thus far have cared about. They just say, yeah, that sounds good. Next. Ridiculous, but it's how it's working. Thanks, Doctor. Appreciate it. Once again, very generous of you. Appreciate you being a supporter of the program. Thank you. We have Lava Java Lava who says, if states' laws supersede Supreme Court powers, wouldn't this be considered a constitutional crisis? Yeah, I mean, yes, you can make that argument, right? If the states can do whatever they want and the Supreme Court basically divests themselves of any of the authority to get in there and fix anything, yeah. What good is the Supreme Court? It's not so supreme anymore, is it? It's kind of unsupreme. It's kind of just like along for the ride, right? We have a number of states in Texas, a number of attorneys generals, people all over the country saying, we got questions about this. Supreme Court says, no, you don't. You don't even have a standing. You don't even have issue here. Do you understand what standing means? It means you don't even have a claim. You can't even bring that. You don't actually have a problem because you're not a party to any of this. You don't even get to raise the issue, right? So yeah, if the Supreme Court bows out again, in my mind, they have abdicated any responsibility for how states govern their elections. And what I would expect to see would be states governing their elections however the hell they want to do it. So we'll see what the Supreme Court says. We have Jennifer who says, Rob, do you think Republicans contesting the electors can be denied entrance on January 6th? I do not think so. I don't know the parliamentary rules or the House order rules or all of that stuff. They kind of have their own set of laws that they use to govern how they do things in the House and the Senate. But if you are an elected person and you have a legitimate basis to enter that building, and you're denied that, in my mind, that is a denial of due process. I think there would be some serious repercussions for that. So I fully expect all of the newly elected Republicans to be there on January 6th, including Matt Gaetz, including Mo Brooks, and I think they're going to object. The question is going to be whether they will see that in the Senate as well. Wolfgang Deo says, is it true that I can go cause mayhem in LA now? Good question, Wolfgang. My understanding is there are a certain number of crimes that the LA sheriff is just not going to be enforcing. I think one of those even is assault on an officer. So LA sheriff, I think it was the LA sheriff, somebody newly elected over in LA said, we're not going to enforce all these crimes because these crimes have been enforced against, I don't know, underprivileged people or something like that. So I wouldn't recommend trying it. I'm not encouraging violence or misconduct in any stretch of the way of the word. Good question, Wolfgang. We have Liberty or Death says, we need to pass it and see what is in it. Mitch McConnell, why on earth should citizens of Texas pay for tyrannical policies of Fredo's brother? Yeah, that's a good question. Liberty or Death. Yeah. Yeah, we need to pass it to see what is in it. Isn't that what Nancy Pelosi said for the Obamacare bill? I think it was. Well, we need to pass it so that people can see what is in it. These Congress people don't read. I bet you could find some Congress people who have a difficult time reading, and they've got a 5,500 page bill. They're going to vote on it without having read it tonight. Okay, that's our government in action. We have Aaron Seavey, who says, shouldn't Trump bring in the military and redo the elections in contested states? It would put this finally to rest. Yeah, Aaron, I know that a lot of people are inclined to want to bring in the military, and I'm just not happy about that idea. I just don't like it. I don't like the idea of a overly powerful government. I don't like an idea of overpowerfully powerful state government, federal government. The government, in my mind, is something to be kept at bay. And when we start talking about bringing the military in to just kind of go in and take control of things, that's sort of the worst case. That's like maximum government. They just come in and do stuff. And, I'm a criminal defense attorney, so my opinion on some of this stuff is going to change, but I am always fighting against the government. That includes any form of government. If the military is going to step in as our acting government, then they become the government. And, my position here is that the government oversteps boundaries. It violates people's rights. It eliminates due process. It puts people in incarceration, unnecessarily. It does a lot of bad things because they have a monopoly on power. And I don't want to extend that monopoly on power to the military and then have them come conduct our elections, because the next time that happens, it may not be Donald Trump. It may not be a Republican. It may not be somebody that I happen to have some agreements with in terms of policy, right? Or you. It may be somebody else. It may be somebody else who we vehemently disagree with. And they could be bringing in the military to do whatever they want. So I am not in favor of using sort of overly broad military. To me, it's almost tyrannical to a certain extent. You would have to have like a benevolent dictator who's going to be willing to come in and sort of implement these rules. And I don't want to play that game, but I understand the frustration there. I understand that. And I think the best way to approach it is just to deal locally. Talk to your local representatives. It's a good question. Thank you. Jenny Wren with another one with a mic drop. Thanks, Jenny. I appreciate that emoji. That's a good one. I haven't seen that one. We have Teresa Child who says, here's my issue about the 600. I didn't lose my job. Was doing great pre-COVID, still doing great, but I got the 1200 and now I get the 600. Why? Yeah, it's a good question, Teresa. And I think you're going to see a lot of that, right? You've got a lot of, individuals, getting money who probably don't need it or shouldn't be getting it. And you have people who really need it who aren't getting it, right? And think about that. The $600, is that going to college students? I think I read that college students were exempt. I think I read that people who are on their parents' insurance and things like that. Like, this thing is a little bit tricky, and it feels like to me that the people who really need it probably aren't getting it, and the people who really don't need it are getting a ton of it, right? Amazon, record profits, Facebook, record profits, all of the tech companies, massive, massive profits. Everybody's doing well, except the small businesses, except the gyms, except people who open up a mom and pop shop and they want to host a cooking class, something like that. Like, I know people like that in this community, and they're all getting devastated, right? It's troubling. Frustrates me. Thanks, Teresa. Appreciate it. Dr. EMB says, this bill is very sad and depressing. What can we do? Well, we're going to see what happens tonight. I don't know if they're going to vote it in. At this point in time, this is one of those bills that you don't act locally on. You got to call your congresspeople. But I think it's too late. I think it's already passed the House. I'm not sure where it's at right now on this program because it was pending before we started almost 2 hours ago. So I'm not sure where it's at. I read the quote earlier that Mitch McConnell, they're going to keep everybody in there until it passes tonight. So, the next step I think is Donald Trump signs it or doesn't sign it. So, this is how your government works. What can you do? They unveil the bill today. Is that accurate? They unveil the bill today and then they pass it tonight. It's 5,500 pages. And they're going to do it literally on the verge of the government shutdown. Because if they don't get it done tonight, the government shuts down. So you see what they do. They've had 6 months to let us know what's going on in this bill. Nothing. Nada. They just release it the day of, at the final deadline so that nobody can read it. Then they're going to all vote to pass it. And they're going to say, we had to do it. We're on a deadline. If we waited one more minute, the government was going to shut down. It's like, hey, idiots, you are the government. What took you so long? Why didn't you, start detailing this stuff at, 6 months ago? Let us know what you're thinking about or start, unveiling these plans because they don't want to do that. They can cram a bunch of pork into this bill that's going to send billions of dollars around the world, even though there's millions of people in the United States that need help and they're not getting it. But the government just wants to just cram this down your throat. And the best way to do that is in the dark of nights, which they're probably going to pass the bill and sign it in the dark of night tonight. That's our government. That's how they do things. Thanks, Doc. We have Eagle Eye in Garden says, hi, Rob and friends. Some kind of remedy for the American people in regards to this stimulus bill. Maybe file a stay or something. Also, Barr is in his retirement. Does this make him available to be a witness? So good questions on that. Good questions. So the stimulus bill, again, I don't know where it's at tonight. Mitch McConnell said it's going to get done tonight. Sounds like Nancy Pelosi's on board. So, they crammed it down our throats already. I'm not real sure that there's much that we can do. Maybe tweet at Donald Trump and tell him, don't sign that stupid bill. Right? That's probably the only recourse you have at this point. If both houses have passed it, I'm going to imagine that Donald Trump signs it into law. So that's what they do. They unveil it one day. Nobody reads it. They pass it, sign. It's done. It's over. What can you do? Nothing. You can call your congresspeople, call your senator, vote them out next time, but that's it. In terms of a stay, any litigation or anything like that, once it gets rolled out, I don't think any lawsuit's going to be successful at unrolling that. You may be able to unroll certain portions of it, but even that I highly doubt. Congress has a ton of authority to pass spending bills. That's one of their primary functions is to spend, right? They have the power of the purse in Congress. So they're the ones who they can pass whatever spending they want. If they all agree on it and the president signs it, it's the end of the game. A question about Barr and his retirement. So Bill Barr is actually making some interesting news. Number one, he's saying that he's not going to appoint a special counsel for Joe Biden and Hunter Biden. They're just going to let that one kind of go, it sounds like. And I think he's also indicated, he said something else about voter fraud. I'm not sure what he said. I can't recall off the top of my head, but can he be a witness? So there is a thing called executive privilege, which means probably not. If he were to, if Trump's people wanted to call him into court, Bill Barr would have to be willing to talk, in other words. So privilege is sort of like attorney-client privilege. So, the judge can't force me to unveil conversations that I have with our clients. Same thing here goes with Bill Barr and the executive. There's executive privilege that I think would extend over to Bill Barr to a certain degree. And then, he would be the one who would be able to waive it. I think he would be able to do that. So if he wanted to go and speak to people, I think that's a different story. But, can they compel him to speak? I don't think so because of that privilege, and for good reason, right? You want some candor in your executive office. If everybody's walking around on pins and needles and everybody can be subpoenaed for everything and they can reveal all of the information, well, then they wouldn't engage in candid, conversations about important things. They would just sort of try to sugarcoat everything and no work would get done. So you want to free people up to have, candid conversations and scream at each other and get down to business without a fear of reprisal. Good questions there, Eagle Eye. Very good questions today. Very, 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 very good questions. We have Aaron Seavey who says, can R&R Law Group help with removal of arrest record in Arizona if no charges are filed? Yeah, you can, Aaron. Actually, it depends on the nature of your case, but there is what's called a petition for innocence that you can file. It's a little bit of a tall hurdle to get that done, but it's called a petition for innocence. So you can Google that or you can give us a call and we'll talk you through it. Thanks, Aaron. We have another one from Fat Boy. from the HK says, I'm a funds lawyer in the UK and thoroughly enjoy your analysis as this is not my era. Can you advise why Trump does not assume the role of plaintiff as most actions were thrown out for lack of locus? Thanks. Yeah, Fat Boy. So, love that name. Fat Boy. Great. So in some cases, he is filing as sort of in his own capacity. So in this new lawsuit, it is his campaign, right? So it is him and him personally through the campaign. In a number of other lawsuits, he has filed personally, but they've been finding other reasons to throw those throw those cases out. And most of the other ones were not on standing; they were on latches. So it kind of goes two ways, right? Standing is saying you don't have the right to bring this claim. There may have been a harm from the lawsuit. There may be a harm here that requires a remedy at law, but you are the wrong person to bring this claim. So we saw that in the Texas case. So Texas was suing Pennsylvania. Supreme Court said, nope, Texas, you can't sue Pennsylvania over this election stuff. You have no standing. So there may be harm, but Texas, you're the wrong person to bring it. So what Donald Trump is doing now is saying, well, okay, fine. We're going to make a lot of those same claims. I am the person bringing it. Okay, I was hurt by this stuff. And so we're going to see what the Supreme Court has to say. Largely when that change has happened, what we've been seeing is latches. So the Pennsylvania Supreme Court said latches, right? When they were suing, they said, okay, you are the right person, therefore you have standing, but you brought the lawsuit too late. Should have brought it earlier, so we're going to rely on latches and throw your lawsuit out on that basis. So technicalities every which way you go. It's going to be hilarious. If the Supreme Court denies Donald Trump and they rely on latches, I don't even know what I'll have to say about that. It might just be the end of the Supreme Court. I mean, I don't know. Maybe they'll do it. I don't know. It'll be a joke if that happens, but we'll see. Good question over there from Fat Boy. Thanks for chiming in over from the UK, my friend. Appreciate you being here. We have Ivan Ramirez who says, if the election is contested, I believe House votes by state delegation, not members, giving a Trump win. Is that correct? That's right. So that would be what's called a contingent election. So the theory there is that you would drop it down. So if any candidate can be under 270 electoral votes, and no candidate reaches 270, which is the magic number, then what happens is you have a contingent election, right? And that means that the states have delegations that vote. Trump has more Republican states than the Democrats do. Trump would be reelected, but they have to contest of Joe Biden's 306 electoral votes. They got to argue over enough of them to drop him below the 270. So they have to invalidate whatever that number is, 36 votes. I think that's what it is, to get him 37. So if they could get him under 270 electoral votes, that is what would trigger a contested election or a contingent election. But all of those votes have to be contested and then thrown out by both House and Senate. So it's a little bit of a hurdle. No question about it. Good question, Ivan. We have LD 2020 who says, will you please look into the crazy Twitter thread saying that Tiffany Dover, the fainting COVID nurse, is deceased and there is a cover up for it? What? I did not hear that one. I did see that video. I didn't know her name was Tiffany Dover, but I did see that, and she did faint. To me, it didn't look like it was a vaccine thing. It looked like she was very highly stressed. You know, the cameras everywhere, COVID, got the vaccine. Oh, I'm feeling woozy. Is that the vaccine? No. Is that the camera? What do I say? And she fainted. If she is deceased, that is a different story. I hope that is not the case. Thanks, LD. We have Isaac Castillo who says, in your purview, is there anything that sticks with you that might be considered standing regarding voting electors and our election in general? So it's a broad question there, Isaac. Anything you might see that is considered standing regarding voting electors and our election in general? So, yeah, I mean, the argument that, there were a number of other lawsuits that were filed as the electors. I'm not sure if that's what you're asking me, but several of the lawsuits were filed on behalf of the electors. So the president wasn't involved. The campaign wasn't involved. It wasn't anything related directly to the campaign. They were saying the people who were harmed here were the electors, right? They were nominated to go do a job. They're being divested of their job, and now they have standing because they were the ones ultimately harmed. They're not going to go and be able to cast their votes. And the courts have, I think, thrown those ones out as well. And I think the basis is because the harm and the remedy don't really, I actually think it's not the best standing argument. I'm having a difficult time gathering my thoughts on it. But what they're saying here is that just because you're an elector, doesn't mean that you are necessarily harmed to the degree that warrants throwing out, let's say, 100,000 votes. Right. So if you're asking the court to throw out a big bucket of votes, you as an elector, the harm is not relative to your role. It's not connected in that way. Your ultimate harm by not being able to go and cast your ballot, your certificate of ascertainment to cast the ballot for the next president, what is it? You don't get to vote? Okay. You don't really get to bring a claim there. Yours is pretty minor. Trump's, by contrast, is huge. Okay. If the harms now are let stand, well, then Trump is not president anymore. Okay, that's a massive harm. That's much different than the electors not being able to vote. So I think that's why a lot of those cases have been dismissed as well. We have AD Finlayson Guitars, who says, hi from the UK, enjoying the show. I hear the Biden Corporation are going to be setting up offices in Burma and the Sudan. Yeah, exactly right. Right. It's sort of the thought process there. Ukraine's getting $450 million too. I mean, they're already pretty well nestled in there with the Ukrainians, but why not just franchise that stuff? The Hunter Biden franchise. Just go Burma, go to Sudan, go to Cambodia. They're opening up. He can go over to Nepal. He can go over to any one of these places, as I'm expecting all these Congress people do. You know, they probably have brothers and family members. I would imagine that if you did one of those boards and you connected the strings to all the different faces, like on the, Law and Order movies, pretty sure you'd be pretty grossed out by what we see. Good question there, AD. Appreciate that. Another one from Isaac. Says that the Dershowitz has weighed in part regards to our election quandary. Are there any cases you'd have enough interest in that you might do a Q&A with him? So yeah, I actually watch Alan Dershowitz from time to time. He's got a pretty good show over there on YouTube, actually. He comments on things and he takes, I think, some pre-recorded calls. Obviously, he's been doing it for about, I think, 150 more years than I have. So he's been doing this for a long time. So I'd be very open to talking to him about any of this stuff. I don't know that I have any particular questions that come to mind right now. I think I'd be more interested in not his legal take. The legal take I get. I understand all of it. I understand why they're, throwing cases out and all that stuff. It's not that interesting to me. What I'd be more interested in is sort of his sort of general thoughts on the processing of the Supreme Court judges. How are they thinking about things? What political considerations are they taking into account? I'm guessing he's probably a lot more plugged in than I am with maybe some of the clerks and some of the sort of the kind of the echo chamber in the legal community. I'm sure he's very well plugged in a way that I'm not, in a way that you can only get if you've been doing it for 80 years. So, that would be something I'd be interested in talking to him about. And obviously an impressive guy, very, very, very massive background. So I would take that opportunity. Good question, Isaac. We have Brian in Bowdoin, who says, if they give the vaccine to minorities and there is something wrong with it and it causes long-lasting effects or death, that would be bad. That would be very bad, not just because of who is getting it currently, but in general, right? We want a vaccine that works if people are going to take it. And, if that sort of backfires, right, if we give it to the people who are most at risk and it turns out maybe the vaccine wasn't quite ready and there's adverse reactions to it in those communities versus other communities, yeah, that's going to open up a whole can of worms. Not good. Good point. We have Me Thompson, who says there is some question as to this vaccine may cause infertility. Doing this to specific races could be entering Hitler territory. I didn't even think about that point. That's a good point, right? What if there are these repercussions? Maybe you don't even know about them three to 5 years from now, right? So it may look good. Everybody's getting over COVID. Everything's good. 3 years later, can't have a kid. Why is that? Oh, did you get the vaccine? Yeah, that's weird. A lot of women are suddenly infertile. That's a problem. And there will be a major backlash if that is the case, for sure. I'm really hopeful that doesn't happen. But we're in uncharted territories in many ways. We have Adam K, who says, how do firms who specialize in criminal defense and pro bono type work operate in a way that remains sustainable and profitable? So it's a good question. So the way that we do things is we're a private law firm. So people hire us privately, right? We're not a group of public defenders. Public defenders, they're paid for by the government. So by your taxes. They have public defender offices. We have several of them here in Arizona. And we have other lawyers who are kind of private lawyers, but who will take, they're called OPDS contracts, so like Office of Public Defender system, whatever that is, contract. So they'll contract with the state government and they'll take some public cases on the side and stuff. We don't do that here, but that's one way, how they operate. So some attorneys who have smaller firms maybe don't want to do any marketing, maybe just kind of want to, just manage a caseload, they can get public contracts, and the government is funded by you, by the taxpayer. And the other ones, say like the Justice Project or any of these other organizations that are pro bono, what they do is they get donations. So people, it's just like a nonprofit. They just generate donations, pay their people based on the donation money, and then that's how they stay in business. But we're a private firm, so people hire us, right? If somebody comes to us and they need help, we have a fee. If that works for them and we decide it's a good working relationship, that's all she wrote, just like any other business. Good question, Adam. Thanks for being here. We have S. Love, who says, "You're too sweet. These high horse riding politicians are not going to desaddle themselves. Sadly, it will require others smacking them down. History is the proof. Don't think local government is going to for us." Yeah, that's a good point. The only reason I talk locally is because there's more accountability there. I've talked about this before. My representation to my senator is like 1 to 8 million people. There's 8 million people in Arizona. Me to my local representative, it's a much smaller number, much, much smaller. I have a lot better chance of getting their earful or making a difference in their campaign with my donation or by, interviewing them for this program or by doing something like that, right? I have more tools that I can use that's going to be more influential for the local lower level candidates than I will be at a higher level. And I think that's just sort of the rule across the board. So that's why I'm encouraging it to, people to just think a little bit more locally. Now, I agree with you largely that politicians are going to politician, and they're all mostly interested in themselves and their next career and how they're going to, stack their cards in a way that's going to leapfrog them. It's going to jump them into whatever the next run is. Governor, senator, whatever that looks like. And so they, you just have to keep that in mind, that they're looking out for number one. Good question. Thanks, S. Love. We have, will Biden be the next president of the United States? Oh my goodness. This is a big one. It's Schmaz 458 asking. So it's a good question, right? Right now, looking like the answer is going to be yes, unless something else happens, right? Joe Biden has more electoral votes. He was certified in all the different states. Those are all going to be opened and counted. Right now, I haven't seen any senators who are willing to object in the counting of the votes, but that can change. There's some that are on the fence, so they would still need to contest those votes, which there would still need to be floor votes on both the Senate and the House. They would need to throw out a certain number of votes to drop it under the 270 threshold. That would trigger the contingent election. It's a possibility. It's a long shot, but it's a possibility. So, that's my answer for you there. We have Wolfgang Deo, who says, for science, does yelling fire in a crowded theater actually result in a stampede? Has anyone tried it? Is it a replicable phenomenon? I think that it is, Wolfgang. I think that actually came from a case. I think that there's a First Amendment case about free speech where somebody did that and they said, no, that doesn't count. You can't do that. Free speech is a pretty expansive doctrine, but there are some things that you just can't say. Fire in a theater is one of those. I can't think of the name or the case, but I'm pretty sure there was an actual case on that. If not, well, I'm sure there is. There's basically a case about everything. You can find a case about anything. There's a whole field of law that is just about research, right? There are people who are just excellent at research. They just go and they find these cases. And you do that for a lot of good legal reasons. But you can basically find whatever you want because we live in a big country and somebody has done just about everything. Every now and then I'll hear a story about something and I'm going, that's new. Wow. But not often. It's kind of a rare thing. Thanks, Wolfgang. We have Curtis Bartle, who says, happy solstice, my friend. Cheers. Cheers to you, Curtis Bartle. Happy solstice. Go out and look at that Christmas star. We have hate that YouTube takes a cut of this, but my love, respect, and admiration for you outweighs how I feel about them. That's how great you are. Thank you. Thanks, S-Love. I really appreciate that. It's humbling. I don't even know how to respond to those types of questions. Honestly, it's just thank you. I'll just say thank you, and I appreciate you being here. Next is Wolfgang Deo, who says, if Biden becomes president, I'm leaving the country. Same if Trump does. Just saying, I'm going on vacation. Not politically related at all. Well, Wolfgang, after this year, I encourage you to do so. I think it'll be well worth it. We could all use a little bit of a vacation, and I'm glad that you're leading the way. We have Cheryl Myers, who says, if SCOTUS hears and rules in Trump's favor in the Pennsylvania suit over constitutional issues, how would that impact the other states in question, like Georgia, Wisconsin, etc.? Good question, Cheryl. And this is where the Supreme Court really makes their money. This is one of those situations where if the Supreme Court came out and said, look, we're going to draw a hard line in the sand on this thing. We do not want courts stepping over the line and crossing into what is the legislature's purview. We're going to say that is not allowed. So what you would look at in Pennsylvania is you would say, okay, well, what did the court do there? Well, the Supreme Court did this, signatures. They did this. They moved the election back 3 days. They counted non-postmarked mail-in ballots, all of those things. So you'd say, okay, if we rolled those back, if the Supreme Court says anything that happens after this line is out, you'd roll all those back. You'd see, okay, how many votes are in each one of those buckets, and you would toss those votes out. So you could see that remedy being successful in Pennsylvania. But the bigger, broader constitutional rule that the Supreme Court would be establishing there is courts can't overstep into the legislature. So you would take that same rule, you'd go over to Michigan, you'd go over to Wisconsin, you'd go over to Georgia, go over to Arizona, Nevada, all of these states, and you'd say, okay, this is the new rule. Where did the court, where did the executive branch, where did the board of electors, where did any of these other, secretaries of state, Brad Raffensperger's, Kathy Boockvar's, Jocelyn Benson's, where did they encroach on the legislature? The Supreme Court said, can't do that anymore. So you would go through literally line by line, file new lawsuits, say, okay, Supreme Court, based on this precedent, they invalidated this, said you can't do this. Here's the case, Pennsylvania versus Trump, whatever, we just saw it. You have to apply the same rule. So they would go into each one of those individual jurisdictions, just apply the rule to the facts of their individual states and see how that shakes out. We have another confirmation from Pinky. Yay. Okay, cool. Tiffany Dover is still alive. Thank goodness. That's good news. Good news. We don't want anybody, we want everybody alive and well. It's Christmas, right? It's Christmas. It's Hanukkah. We're all celebrating. Whatever your particular variety of celebration is, we want everybody alive and well and healthy for that. We have another one coming in from Fat Boy who says, well, that's a big one. I don't know what that is, but that's a nice color. It says, my colleague alerted me that Biden's brother is a senior partner at Beeman Law Group, whose chief strategist, Jeremy Atlers, has been disbarred for misappropriation of clients' funds. How can that firm stay in practice? Is this known in the U.S.? So good question, Fat Boy. I did not know that. No, I did not know that. His chief strategist is Jeremy Atlers. He's been disbarred from, yeah. So here's how that works. So, law firms are partnerships in many situations, or they're corporations, and you can have a number of different people who are all a part of that. So if it's a big law firm like Beeman Law Group and one of the partners does something wrong, it doesn't take down the whole firm. That partner is just going to go, right? If he's been disbarred, he's no longer a lawyer. Now, that might mean a lot of things. It may mean that he doesn't practice law anymore, but he may be very well plugged in. He may be rehired as a consultant or transitioned to a consultant, or now he's a external advisor, or he's on, the advisory board or something like that, because he still brings in a lot of money. He's got good relationships. People like him. He's built up a Rolodex for a certain number of years. So even though he may be disbarred for misappropriating some funds, the law firm may just say, he's good with us. That's okay. And they may keep him on. So he may lose his law license, but not ever be kicked out of the law firm. Now, I think that's bad business, right? If you have somebody who's working for you, who's stealing funds from you, my first instinct is to say, okay, well, you're not allowed to steal from anybody. So bye, right? You can't work here anymore. So I don't know what the specifics are out of the Beeman Law Group, but interesting, right? Very interesting. Biden's family has a lot of interesting connections, and I suspect that we are probably going to be talking about a lot of it in the upcoming months. We talked a lot about the Biden stuff before the election. We did a lot on Hunter Biden and all of the malfeasance going on there for a long time. We ignored it for a long time because there weren't any formal documents until we saw that there was a search warrant, and now there's now there's a little bit of a magnifying glass on them. So I'm sure we're going to be covering more and more of it. We will hope to have you back for that, Fat Boy. Thanks for that nice super chat. Really appreciate you being here. We have Wolfgang Deo says, Jesus compelled me to care as a bystander. Is this not standing? I'm filing on behalf of him. Lawsuits for Jesus for Wolfgang. Lawsuits for Jesus. And, it's a good argument. We'll see if that works out. Thanks, Wolfgang. We have a couple more from Wolfgang, who looks like he's wrapping us up here. He says, Trump loses legitimacy if military and martial law becomes involved. I would start fighting at that point, at least as far as things stand now. Yeah, I kind of agree with that. I think that, if Trump, let's say Trump brought in the military, they reran elections, Trump wins all of the battleground states, and then he just secures himself a second term. Do you think anybody's going to think that was legitimate? Probably not. It's kind of the reverse problem that we have right now. Now all of the Democrats are going to be saying he stole this election. He literally stole it with the military. And they'd have a good argument on that, right? Because he brought the military in. It'd be concerning, certainly. And I don't think it's the right way. It'd be good to have the court of law help us sort some of this stuff out and see where it goes. Thanks, Wolfgang. Last one of the program is another one from Wolfgang. He says, all I want in 2021 is more R&R. Love y'all. Love you back, Wolfgang. Thanks for the support. And I want to thank everybody here for being a part of the program. This is a little bit of a long one. It's looking like 2 hours and 12 minutes, which is just great because there's a lot to talk about. We had a nice deep dive on the Supreme Court lawsuit, and I'm sure there's going to be more information to talk about there. I do want to invite you at this point in time to make sure that you're subscribed. If you're not a regular of the program, we go live every day at this time, and I want you to join us again. So a good subscribe would be awesome if you haven't already done so, and a thumbs up and a share. We try to have some reasonable, some fun, some, sort of dinner time around the table conversations. And so if you know anybody who you think would be beneficial to our conversation, I'd love it if you invited them on over to the program as well. As another reminder, all of the slides are going to be in our Discord chat server, so you can find the link in the description. We talk before the show, after the show. Miss Faith uploads the slides, and you can get a copy of my book in there. It's called Beginning to Winning. This is the hard copy, which is available on Amazon. It's How to Fight Your Case and Succeed in the Criminal Justice System, written by yours truly. So it is available on Amazon if you want to take a look, but there is a free PDF copy in the Discord server. So head on over there, grab a copy if you want. If you do read it and you find it helpful or it's somewhat insightful, an Amazon review would be awesome. That helps us out. We send this book to a lot of people who are in difficult positions, and I'm hopeful that they get some value out of it. And if you do, I would appreciate that as well. One more final thought here is that anybody you know or love who's been charged with a crime in the state of Arizona, that's what we do. That's our day job. That's what we can help them with more than anything. We're very good at what we do. We have an awesome team here in Scottsdale over at the R&R Law Group. We offer free case evaluations. We can work with people on payments and things because I know it's, times are tough out there. Everybody's getting $600. Great. What can they do with that? So I get it. We get it. And so we can work with people. We have a real big passion for helping people through the system. I do not like to see people come out the other end in a worse position. I think that's bad for society. It's bad for them. It's bad for the courts. It's bad for the prosecutors. It's bad for the cops. We want people to, if they've been in trouble, okay, that's fine. Let's get them through the system without wrecking everything so that they can become good, more productive members of society and not leave it in a worse position. So we would be honored if you sent them our way. A referral from you would mean the world to us, and we'll take very good care of them. Other than that, my friends, let me just sign off by saying thanks so much for being here. We'll be back here tomorrow, same time. It's going to be 5 p.m. Arizona time, 4 p.m. over in California on the West Coast, 6 p.m. Central over there in Texas, 7 p.m. Eastern time. We'll be right back here tomorrow. So everybody, do not forget, go take a look at the Jupiter, Saturn event tonight. It's going to be the Christmas star. Another good time to just sort of settle in, think about what 2021 looks like, manifest what the next year of your life is going to look like. It's a good time to do it. The universe is in alignment to help you reach your goals. So I'm going to be doing that, and hope you do the same as well. I'll leave you with that. Everybody have a very wonderful night. Have a nice, restful night's sleep. I will see you back here tomorrow, same time. Don't miss it. Bye-bye.